All right, everybody. See if we got our audio up. And now, oh, whoops. I'm running a little behind today, so I'm doing some of the stuff I normally do kind of on the fly. Make sure. See if we're live. Still no connection from the robes. Let me know if you guys. Oregano? I'm with you. Where am I looking? Oh, right. Okay. Switching accounts. All right, let's try. Double check the stream. It should be live by now. I don't know why they're. Let me try a reload. There we go, maybe. Make sure. Don't know if there will be decisions today. Oh, they're swearing in new members. Okay, yeah, that might take a few.
Be seated.
We will hear argument first this morning in Case 25-112, Chatrie versus United States. Mr. Unikowski.
Mr. Chief Justice, and may it please the Court, the government conducted a search of petitioner's location history, and the warrant that purported to authorize that search violated the Fourth Amendment. The government conducted a search. The Court should hold that people have a property interest in their data, in their accounts on the cloud. Location history has the core attributes of property. Petitioner had a right to exclude, to control, and to destroy. Additionally, petitioner had a reasonable expectation of privacy in his location history, given both its sensitive and revealing nature and the fact that it was stored in his password-protected account. The warrant violated the Fourth Amendment. The warrant authorized the government to direct Google to search every single person's account to find those people who were within the geofence. That is a general warrant. Even if the search materialized only when the data was found and exposed to the police, the warrant would still be unconstitutional because there was not probable cause to search the virtual private papers of every single person within the geofence merely because of their proximity to the crime. Finally, at Step 2 and Step 3, the search violated the Fourth Amendment because the warrant gave the police unlimited discretion to decide who to search while casting Google into the role of magistrate. I welcome the Court's questions.
How exactly did the warrant violate petitioners' rights at the Fourth Amendment rights at step one?
So at step one, we understand this warrant to have authorized.
I thought it was anonymized at step one.
That's true. So from our perspective at step one, we believe that there was a search of every single account, and alternatively, at a minimum, there was a search of the accounts of all the people whose data was exposed to Google, but either way, we view that as a search that the warrant authorized. But let me specifically answer your question about anonymity. We view the anonymity in this case as both irrelevant to the Fourth Amendment analysis and also rather illusory. So first of all, I don't think anonymity matters because I think a search is a search even if you don't know the target of the search. Like if you go to a bank and you break open a safety deposit box, I'm sorry, Your Honor, do you have a question? No. If you go to the bank and break open a safety deposit box, even if you don't know who owns the box, if you inspect the papers, I still think that counts as a search. As well as a practical matter, anonymity is somewhat illusory because one's movements within the geofence often functions as a kind of fingerprint. You can figure out who the person is based on a fairly small amount of movements. In this very case, our expert was able to identify 3 purportedly anonymous people via a close analysis of their movements as well as some public records.
So if you don't want the government to have your location history, you just flip that off. You don't have to have that feature on your phone. So what's the issue?
I take the point that you can flip it off, but I guess I just don't agree that one should have to flip off one's location history as well as other cloud services to avoid government surveillance. I mean, by the same token, you don't have to send email. You can flick that off as well, but that doesn't imply that you're implicitly consenting to the government searching one's email.
Well, not implicitly consenting, but the only reason the government has access to this information is because you've decided to make it public to the extent it can be accessed by people any number of ways. In other words, people can use that information, not simply law enforcement.
Well, I guess
it's like if you don't want them to peer into your window, you can close your window or the shades.
I take the point, Your Honor, but I guess I'd respectfully disagree with that assessment for a couple of reasons. So first of all, I think you could say the same thing about sending mail. If you don't want the government to look in your mail, you don't have to send it and give it to the Postal Service, or the same thing with a safety deposit box. But I think that one should be permitted to hand over data to a third party without assuming the government is going to look at it, especially since it's true in this case petitioner was convicted of the crime, but geofence warrants mostly ensnare innocent people. In this case, you had 19 people within the geofence whose data was exposed, as well as 2 other devices whose actual identity was exposed. And Google received 9,000 of these warrants in 2019. So I don't think an innocent person should have to shut off these services as a condition of not being surveilled.
Do the numbers make a difference? Would it matter if only 1% of users enabled location history?
I don't think it should matter. The government has made a point about the fact that only 1/3 enabled it, but I actually don't think those matters really are significant. Because if you view a person as having a property interest in the data, in other words, if you treat one's account as kind of a virtual safety deposit box, then I don't think it matters how many people have these virtual safety deposit boxes. Even if it's only one, if the legal relationship to the data is similar to the legal relationship between someone who sends a package.
Mr. Unikowski, it's not just a question of shutting, it's not a question of shutting it off. It's a question of turning it on. And according to the government, your client had to go through multiple steps in order to turn it on. So he voluntarily disclosed to Google the information about where he was going to be.
So if I could make 2 points about the voluntariness argument that the government advances. So first of all, I actually don't think it should matter for Fourth Amendment purposes that there was voluntariness, because it's quite common for people to consent to putting their data in the cloud, in the sense of every time you send an email or you send a document, have a Google Calendar entry, all those things you're consenting to sending it in an encrypted fashion from your phone to the cloud. But I don't think that the consent merely to have your data stored in this virtual storage locker in and of itself is consent to disclose to the government.
He not only turned it on, but had he read his contract with Google, he could see that Google retained the right to turn this information over to law enforcement if it thought that that was appropriate.
That is the same provision that exists for everything that you store in Google servers, including email and documents and everything else. So it seems to me if you're going to accept that argument, then that is really the end of the Fourth Amendment for any private document you're storing with Google.
Suppose Google, put that warning in red and it flashed a lot and it was totally noticeable. We can give this to the government. Would that make a difference?
If there is a flashing warning saying that, we reserve the right to give for any reason whatsoever, I think that might be more pertinent to the property theory than the privacy theory, because on the privacy theory, the court said in the Byrd case that, terms of use aren't necessarily dispositive. They should look at sort of general expectations. I mean, maybe if it was like really flashing and saying, like, we are the government's partner, we give data to the government all the time, maybe that would result in a different analysis based on one's reasonable expectations. Under the property theory, it might be relevant because one of our arguments here is that the terms of development are that Google could possess this information but couldn't necessarily turn it over. There was a strict privacy policy, so it wouldn't turn it over to advertisers.
That privacy policy, the terms of service, pretty much, and I'm paraphrasing here, we will respond to lawful requests from the government. I don't know whether one even needs to say such a thing, right? I mean, it's anybody who gets a warrant, and a lawful warrant has to comply with it. A bank, a doctor, a lawyer, anybody. So it doesn't seem to me to add a great deal to the analysis. And are the terms of service here materially different than they are for email and for Google Documents?
Gustav, I think the difference is rather than terms of service, this is
the
when
U.S.
it
Postal Service has the
flashes
same
up a
provision in
warrant.
their terms of use. Will comply with search warrants.
Do you
but
comply?
I think a search warrant is still needed there. And on the second point, no. The general language that the government will, that Google will comply with search warrants and that Google will, reveal aggregated information like what's the most searched term of last year. It turns out it's YouTube. Like that type of disclosure that applies to all data that's stored at Google, not just location.
So if we were to rule that there was a voluntary exposure here to Google that allows the government unfettered access to it, that ruling would pertain equally to email.
That's correct. Essentially, all of your data on the cloud, which is kind of all of your data, if you use a computer, would be exposed to government searches without a warrant.
So where do you think voluntariness matters and where not? What you're suggesting is really that's the wrong question here. When is it the right question and when is it the wrong question?
So I think there might be a voluntariness issue when it's very clear from the interaction that you really are consenting to the other person doing whatever they want with it, such as when you give information to someone knowing that someone is going to use it as a business record. So I think that the Miller case, for example, we're certainly not disputing the holding of Miller. And in the Miller case, the court explained that if you put a check into the stream of commerce, okay, so you give it to a vendor, and then the vendor gives it to their bank, and then their bank gives it to your bank, and it becomes their business record. You can't control it. They keep it for their purposes. You can't delete it. You have voluntarily put something into the stream of commerce, and you've sort of given up control over it in the relevant sense. And so on that fact pattern, the court said that you have relinquished an expectation of privacy. And there's a similar holding in the Smith case. The court said that when you give your phone number to the phone company, you know it's their record. They're putting it on your phone bill. They're using it for all kinds of business purposes. It's exactly like it used to be when you just talked to a telephone operator. And in that case, you're not just giving someone information like you're mailing something, but you're like giving consent for them to treat it as theirs. And that's the fact pattern that I think the court has said that the voluntariness of that transfer of property is sufficient to say that you've given up your reasonable expectation of privacy as well as your property interests.
Mr. Unikowski,
Remember
I'm
that
struggling
Congress
to
can
understand
do the stuff for today.
why we are hearing this case, other than the fact that at least 4 of us voted to take it. 14 of the 15 judges on the en banc Fourth Circuit voted to affirm. 9 relied on the good faith exception. Unless you think that we're going to say something that convinces,
There we go, good faith.
that unless you think we are going to say no reasonable officer could believe that this was a valid warrant, or we're going to say something that will convince the judges on the Fourth Circuit to reach that conclusion, what you're asking for is an advisory opinion. That's number 1. This involves a Google feature that it doesn't exist any longer. That's number 2. It involves a warrant that is structured in a particular way. That's number 3. We are all free to write law review articles on this fascinating subject. But that seems to be what you're asking for. Asking for basically a law review article on a subject that it is largely unexplored by our precedents.
So let me tick through each of those points, Your Honor. So first of all, as to the good faith exception, the court did not grant certiorari on that question, and so we didn't brief it. So all we'd ask for in this case is if the court finds a Fourth Amendment violation, to reverse and send it back to the Fourth Circuit to consider the good faith issue in view of this court's guidance. Now, I admit it's going to be hard for us on the facts of this case to say that the officer acted maliciously or that the legal issues are obvious. I think if there's anything obvious from the briefs in this case is that they're not obvious. We would make a different argument. We'd say that the Leon good faith exception applies to fact-bound challenges to probable cause determinations in a particular case and shouldn't apply where we're challenging a new and fundamentally different type of warrant. And if you look at Leon, there's some language in there that says that the exclusionary rule, even in cases of warrants, should be considered on a case-by-case basis, and exclusion is warranted in the unusual context where it would advance the purposes of the exclusionary rule. So we just like a chance to make that case in the Fourth Circuit with the benefit of the court's guidance. In terms of the issue that Google has discontinued the censor vault and has put the data onto people's phones, first of all, this was fully ventilated at the certiorari stage. I don't think that there's any surprises that are in the merits briefs in this case. I think this is an important subject because lots of providers store data, not just Google. There's something like 30 amicus briefs or 29 amicus briefs in this case, including by many of the titans of the tech world. And so I think a lot of people think that this case will have implications beyond these particular facts. So we'd urge the court to decide the question on which it granted certiorari.
Well, we can affirm on any ground that would support the judgment and was raised below, and the good faith exception.
You can do whatever the heck you want.
All those points. So the fact that the court did not grant certiorari on the good faith exception does not preclude any of us from relying on that.
I'm not sure I agree. The court specifically declined certiorari on that question, so we didn't brief it. And we raised in our cert petition that we'd like the chance to argue that the questions are intertwined, and in view of a holding on the Fourth Amendment issue, we'd like to litigate the good faith issue. The court didn't grant certiorari. We didn't brief it. The government did have a section of the respondent's brief addressing the good faith exception, but adhering to the court's decision not to grant certiorari, we didn't respond in the reply brief except to ask for a remand. So,
well, that was your choice.
the court did not grant certiorari.
They granted on the exclusion rule,
which the court specifically
which
you're
includes.
an experienced advocate. You understand that we can affirm on an issue that was raised below and would support.
What are you
the
doing?
judgment.
Look, I'm happy to argue the issue from the podium, Your Honor. I'll just say one word about it. I think that the premise of Leon is that it's not necessary to apply the exclusionary rule in a case of a fact-bound challenge to a probable cause determination in a particular case, because probable cause is litigated all the time outside the context of warrants. Whereas in an issue like this, a challenge to a fundamental new type of warrant, I do think litigants need an adequate incentive to litigate the constitutionality of such warrants, and the only way that'll happen is through the exclusionary rule. And there is some language in the Davis case that adverts to holding that in cases where you need an adequate incentive to litigate an issue, the court would consider applying the.
And Mr. Unikowski, isn't there also a pretty significant split, even within the Fourth Circuit, over the issue of whether or not there was a search in this context? I mean, my understanding is that the Fourth Circuit split evenly, 7-7, on that pretty significant issue.
That is correct. It was 7-7 with one judge declining to reach the issue. So obviously there's some important issues that go well beyond the particular facts of this case. And there's also some important issues in terms of the constitutionality of the warrant that go well beyond
Jackson
the facts.
with the save.
Counsel, I just want to button down some of your answers. The privacy policy that the person is giving consent to would affect, you said internet, but it would also affect Google Photos, which have to do with what photos you take and store in your device, correct?
Correct.
Google Documents, what documents you store.
Correct.
Google Calendar.
Yeah, share this.
Your entire
People
calendar.
need to be watching this.
If this is consent, that means the government can seek those
And
documents
hit like and all that
for
stuff.
any reason, not just the commission of a crime, or no reason, correct?
Correct. It would not be a search, so no search warrant would be required.
So that means the government, a police officer, randomly, who decides, I don't like that person, let me just go look at their life to see if I can find a crime, that would be okay.
There might be some constraints under the Stored Communications Act, but as far as the Fourth Amendment is
Right,
concerned,
but
no.
that's not at issue here.
Correct.
All right. And that wouldn't be for other things,
Correct.
for some of these things, like calendar entries.
So there might be a question as to whether calendar entries are protected as a statutory matter, but again, we're here under the Fourth Amendment.
And
so
we
that's-
can't ignore today
Gustav, that was
that the
one
district
argument.
court made findings that the consent here was not necessarily voluntary.
There are
it
findings
wasn't
that
voluntary.
at midnight
Except
when
that
you're saying, yes, I'm
two-thirds
in
of the
to try to get
people
your phone to work
said no.
correctly, that may not be a consent to the government searching
And
your
there's
phone.
certainly Google documents that show that it's very hard, and if not opaque, to figure out how to turn these things off, correct?
Yes.
Now, let's go to your,
There are definitely concerns.
your general warrant theory. I understood at the founding, a general warrant was,
This
I have
is
a
a big deal.
crime, and a magistrate permitting you to go willy-nilly anywhere you want, to anyone you want, to search them. I thought that was the purpose of general warrant, correct?
Yes.
That's not what this does. This identifies a place, a crime, a limited time frame, but a time frame. So it's not a general warrant in its historical sense.
Except,
Why isn't this closer to the warrants that we've permitted with beepers, where we don't have a person
please nail
or
this answer.
necessarily a
This is a
place
very
in
nailable
mind, but we have a
answer.
location and general things. Why isn't that more consonant with Berger, Zucker, Caro, those lines of cases? And that didn't identify a person, but it identified a crime, a place, and the nature of the unlawful conduct that we were looking for.
Shelley, no kidding.
Sure. So let me say a few words as to why I think this should be considered a general warrant, and then a few words about why the warrant was defective, even if you disagree with me on the first few words I say. So first of all, I think the right way to think about this search is to say, one, that Google, because it received a search warrant, was acting as the agent of the government, and two, that
Under
Google
color of
really
law.
did search every single person's virtual private safety deposit box.
There we go.
So as to the first part of that, this court has said that when a third party is acting with the encouragement, endorsement, or participation of the government in executing a search warrant, that third party is...
Can I pause you there?
Yes.
It wasn't Google doing it, it was a filter doing it.
Well, it was...
I mean, the filter is not the government, it's not even Google, it's a mechanical item that sorts. So why isn't,
All right.
so how could that be a search? Seems to me that the only search would be handing it over to the government.
So let me say a few
Step
words.
one, basically.
Sure. Let me say a few words about that and then say why, even if the search is the handing over, the warrant is still defective. So as to the first part, you're absolutely right. There's not a human being sifting through 500 million people's accounts. That would take an extremely long time. At the end of the day, it was a piece of software that was going through every account, piercing, from our perspective, every virtual safety deposit box and checking inside to see whether the person was there that day. So I still think that when you're using software to search someone's phone, which is how any kind of digital search operates today, that's still a type of search because it's using a tool in order to detect information. And it's true that it's a tool, it's not the human being that's looking at it, but it's still a human effort to pierce a private area in order to find something that's there.
Would that mean all database searches are searches for Fourth Amendment purposes?
Absolutely not, Your Honor. That is not our position. I think this is a unique case because Google's Sensor Vault really is structured like a row of virtual safety deposit boxes, individual accounts. It's indexed by account, which means you have to put in your own credentials to get to your account, and that doesn't get you to anyone else's. So it's exactly like a bank with safety deposit boxes, except it's in the cloud.
So does everything depend on
better
how a
metaphor you can
company
come up with.
organizes its information?
I don't think everything depends on that. I think that this is a unique case because the fact that Google organizes its data that way is not some kind of arbitrary engineering decision. It really is essential to the security of a system with lots of private accounts to index them by account. So the technologist amicus brief, I think, has a good analogy here. It says that it's not arbitrary that a hotel divides different people into different rooms as opposed to stacking all of the bunk beds in the lobby. Like a hotel, which divides people into different places, it's logical to have walls between them. And in this case, there's virtual walls as opposed to physical walls. But I don't think that the fact that Google could have constructed its system in a completely different and, from our perspective, inappropriate way should affect the analysis. But just, I'm sorry.
Sorry, finish, please.
No, please go ahead.
I was just going to say, this seems very complicated from the user's point of view. Frankly, I have no idea how my data is stored and whether it's in these virtual lockers or not. And I guess one question that I have for you is I'm struggling to decide how to think about this case. One way to think about this case is that, listen, our physical intrusion cases, our property cases require a physical intrusion, and CAT set us off on this course that when we're talking about technology, we think about it in terms of reasonable expectations of privacy.
Please don't.
And I am, frankly, a little bit nervous. I mean, I think the government
Don't
makes
overturn
this point well.
cats.
I'm a little bit nervous because this is very complicated, right? Figuring out how bailments apply, what the property interest in this data is. Why not just think about this from the perspective of reasonable expectation of privacy?
Oh,
That would be
thank
fine with
God.
us, Your Honor. We've offered two alternative paths. Different members of the court have articulated the
Right.
relevant test differently. I mean, in Carpenter, the court relied on reasonable expectations of privacy. We think there's two different sources
You guys
here
have
of
no
the reasonable
idea how good a
expectation.
news that was.
One
Hold
is
on.
the fact that it was stored in the password-protected account. This court has said that property issues are instructive as to the reasonable expectations, even if not dispositive. So if you think it matters that this was in his password-protected account, you can say that that's pertinent to the privacy inquiry without getting into this trespass and bailment law, as well as the sensitivity of the data, which was at issue.
Okay, well, this is pretty, so I think Carpenter, we haven't talked about Carpenter yet, is pretty on point, but this is different from Carpenter, putting aside that this was in a password-protected account, taking out of the fact that Google had the right to use this for advertising purposes, right? I mean, this was a few hours and it was a public location, and nobody has a reasonable expectation of privacy in their public observable movements. So does that make this different from Carpenter?
So I still think that even though the stretch of time was lower than in Carpenter, there is still a reasonable expectation of privacy for a few reasons. First of all, I don't think it's just the 2 hours. I think it's the forever. It's the comprehensiveness and the ability of the government to get access to really any 2-hour stretch anywhere it wants to at any point in the past. I think it's quite different from a case like Knott's, where the police were following someone on a highway and they put a beeper just to enhance the quality of the visual surveillance. And so, this court in Carpenter framed the question as, are police doing what they could have done in the past? Or is this a fundamental increase in the ability of law enforcement to conduct surveillance? And here I think it is. I mean, the government has this tool. It can go any point in the past at any stretch of time. It could figure out where, all of the people rather than just one person in a particular place, and it can follow that person around. Like we see in this case of the 9 people who are of greatest interest to the government at step 1, it followed those people around outside the geofence at step 2. And I think that all of those considerations create significant privacy implications, even though it's true the initial geofence was just an hour.
But you can't raise the Fourth Amendment issues or the Fourth Amendment rights of the other people who might be captured in the geofence. We're really just talking about your client's Fourth Amendment rights, right? I mean, because you keep pointing out, well, this swept in a lot of innocent people, sure, but really it's your client's Fourth Amendment rights that we care about here.
That's true. I just think, broadly speaking, when we're considering the privacy implications of the rule and reasonable expectations of privacy, I just think it's relevant, what the court's rule is, how is it going to affect, third parties. I understand it's just petitioners' rights at stake, but even staying laser focused on petitioner, this was a law enforcement tool that allowed the government to determine where petitioner himself was at any point in the past.
Mr. Eunuch?
Yes, sir.
Oh, sorry. Are you done?
Only in public places, though.
Well, the government has taken the position in its brief that even if you're in your own house and a geofence warrant is used, the government has a footnote suggesting that there wouldn't be a constitutional violation either. Obviously, this case did involve a bank. I acknowledge that. Although, just one other word, because of the error bars, because of the confidence intervals in some of these estimates, actually, those confidence intervals may have encompassed people's homes. And in fact, 3 of the people within the geofence went to their houses and were possibly identified by our expert.
So I wanted to invite you to finish your answer to Justice Sotomayor when you said you tried to defend the general warrant analysis, and then you said, even if you don't agree with that, I have another point. But before you do that, let me just home in for a second on the general warrant analysis. If we take Justice Barrett's point that this is really about reasonable expectation of privacy, what about the initial sorting intrudes on anyone's reasonable expectation of privacy?
I guess I just think that if I have, information in a physical storage, safety deposit box, I guess I think that my expectation is that no one's going to look inside for any reason, even if a tool is used, like, the Kylo tool, the thermovision, for any reason. If I have stuff inside, people won't look at it in order to conduct a law enforcement investigation. And I understand the intrusion at step 1 was fairly limited. It was just a computer zipping past all these accounts, just checking quickly whether they were in a particular place. But, cases like Jones say that even a very small trespass is enough. But I see my red light is on. If I could just answer Your Honor's second question.
Well, why don't you wait till we get back
Okay.
to that? It seems to me that the exigent circumstances exception could well expand if you're right. I mean, obviously, you have situations where somebody in this particular crowd is snatched a child or was involved
Yeah, I
with
think
somebody who
she's
snatched a child.
like a year
In
or
those
two older than
situations,
me.
I suppose you
Or
agree
maybe
that you don't have to go through a warrant process, but can access the information under exigent circumstances?
I do. The court made that very clear in Carpenter. I mean, this warrant was sought several weeks after the crime, and so any exigent circumstances, I think, argument would have gone away. Our position today is not intended to undermine any well-recognized exception of the warrant.
Well, my question is whether intended or not, whether it could be used to expand it a great deal. I mean, what's exigent can be expanded if, in fact, it makes sense. Which when you have, you don't have this much access, you can't, doesn't do any good to say, okay, you have to search to find out who all these people are. But if the push of a button, you can find out who they are. That might give you more opportunities to avail yourself of the exception. I don't know which way that cuts, but it does seem to me that it might undermine privacy interests further, or cut the other way in sense of giving you more opportunities to perhaps catch people who are, planted a bomb or whatever.
Look, if there's an ongoing emergency with a bomb, I mean, we're not going to argue against the use of these law enforcement tools, even if there might be, a significant amount of privacy violations. And so, yeah, I mean, this can be a potentially useful tool in the case of a bona fide exigent circumstances. We're certainly not challenging that. You're right.
Justice Thomas, anything further? Justice Alito?
So Thomas and
Justice
Alito
Kagan
both
asked you whether
think
this would apply to
this is all about property law.
Searches, all digital searches.
And Gorsuch.
Let me go back to
Not
the
privacy.
pre-digital era. It's not at all uncommon, it was not all uncommon for a grand jury to issue a subpoena requiring a company to turn over a category of particularly described documents, but that for the company to find those documents required a search through a vast store of hard copy documents. What's the difference between this situation and that situation?
So I don't think a grand jury subpoena or any kind of subpoena would have been constitutionally permissible in this case.
Well, I know you say that, but what is our test for determining when a grand jury subpoena violates the Fourth Amendment?
So I think there's two circumstances when it does. One is when the holder of the documents are really a bailee of someone else's documents. So one example would be a grand jury subpoena directed at the Postal Service or FedEx, asking it to open every single package or piece of mail to find a piece of data. Or,
when it's the company's own documents.
Right, so when it's so of course, as we've said, we don't think that's this case. But when it's the company's own documents, I just go back to the test in Carpenter, which is there's a narrow category of cases in which a person will have a reasonable expectation of privacy in business records held by a company, and in that category of cases, the subpoena is unconstitutional.
Well, I'm sorry, go ahead.
No, please.
Well, in Carpenter, what seemed to be a very important feature, I think maybe a dispositive feature, was that the information that was sought was information that the user of the cell phone had no choice but to disclose, because the cell phone tower location is an indispensable feature of actually using
Hold
your
up,
phone.
Benjamin. I'll
That
type
is
it on the
not
screen. 1 second.
situation here.
I take the point that it's possible to function in society without having location history enabled, although it's actually quite hard to function without having anything in the cloud. I'd say virtually everyone in this room has at least something in the cloud.
Well, but we're not talking about everything in the cloud. We're talking about location history.
Right, it's actually quite hard.
On an Android phone, where you have to take a number of steps in order to disclose it. So you have to choose to disclose it.
I take the point that you have to click yes, I'm in order to enable location history on your Android phone or any other type of phone. But first of all, if you agree with us that this is a personal record and not a business record, that argument just doesn't matter, because you make the choice to enable email or put documents or photographs into the cloud. You're choosing to send that photograph, but that choice shouldn't undermine the Fourth Amendment protection, just like your choice to put something in the mail.
Well, you think this is not a commercial record? Why do you think Google compiles this, keeps this information? It does it so it can sell advertisements.
No, Google itself takes the position that these are not business records. I understand it's just a third party's view, but it's unusual for a company to refuse to say that something's its own records. Unlike with CSLI, you have total, as Your Honor said, you can turn it on, you can turn it off, you can delete all of it anytime you want, you can delete part of it. It's really unlike something like CSLI, in which you have the business keeping the records for its own purposes.
Counsel,
Does that make sense,
I'm
Benjamin?
sorry, are you through?
You're
I want to go back to Justice Barrett's, if you're not through, Sam, I thought you were through.
Go ahead.
Sammy.
To go back to Justice Barrett's question, when the police are searching or asking for a search result, there's no way to predict whether they're going to invade your privacy, correct?
That's right. Searches are determined ex ante.
Regrettably, because people take their phone now everywhere, including, I suspect, some people to the bathroom, you really have no idea what information, private information, because it'll follow you to a brothel.
Thank you,
It'll
Sotomayor.
follow you to a cannabis shop. It'll follow you to just about anywhere where there's a reasonable expectation of privacy, correct?
Yes.
And so it really doesn't matter. I don't think the time is important, correct?
I agree with that.
So whether it's a minute that you're searching for or 6 weeks, it's not the time that's at issue. It's whether or not private information in which you have a reasonable expectation of privacy will be sought, correct?
Yes.
That's why Justice Scalia said it didn't matter for Fourth Amendment purposes to search the heat waves emanating from your house, because though it's not giving out private information, you can't know in advance what it's going to disclose, correct?
Yes.
All right, now let's go to that more important part of the question that Justice Barrett asked, which is, we didn't answer this question in Carpenter, but I don't see how its logic made time the defining characteristic. Could you explain why not? It
Sure.
would seem to me that particularity has nothing to do with time. It has to do with the relationship of time to the circumstance that justifies the need.
Right. So there's two questions about time, one of whether there's a search at all, and then the second question of whether the warrant was sufficiently particularized. So as to the first question, I don't think the time period should matter as to the search because, I don't think the court should be in the business of drawing lines between 7 days and 2 days and 24 hours, especially since the government gets to choose the time interval. So 2 hours at a place selected by the government really can reveal a lot.
Sure, but the government in setting forth the warrant has to give a reason for why that 2 hours is reasonable.
Of
correct?
course. So that gets to the question of particularization, and that goes to the warrant. And I would like to say a few words about what the court should do if it doesn't agree with me that this is a general warrant in which all tens of millions of people were searched. We still think there is a Fourth Amendment violation because there wasn't probable cause to search all 19 people within the geofence merely because of their proximity to the crime. I get the fact that a time period was specified.
Well, Google itself said that to them, and I don't know why why we would say it's okay to rely on Google to do that. They moved it from 19 to 9, wasn't it?
That was at step 2, Your Honor.
Oh, step 2. Okay.
Yes, but at step 1, 19 people's information was exposed merely because they were near the scene of the crime. And so I don't think that the I understand that the warrant specified a time period, but the particularity requirement in the Fourth Amendment requires particularity as to what is searched. And I don't think that there is, certainly I don't think there's particularization here when the warrant just said, whatever unspecified number of people are in the proximity of the crime, those are the people to be searched. I don't think that's a particularized description of what is to be searched. And I think there's a probable cause problem here because the fact that someone's near the crime doesn't create probable cause to search their diary, and we view this as the functional equivalent of a search of their diary.
At the end, I'll tell you guys about my experience with particularity and writing a warrant.
Because you were saying that this was the answer if we rejected your categorical argument. Is that correct?
If you reject our argument that there's been a search of millions of people, then yes.
Yeah, but functionally, isn't that argument going to be the same? In other words, it's going to prevent the government from doing this kind of search in order to get these 19 people?
Not necessarily. So sort of a narrower argument would be that if there's probable cause to really believe that every single person in the geofence has relevant information, then that's a stronger case for the government. So that might come up, for example, suppose there's a murder in the woods and it's 3 a.m. and there's one criminal and one victim, and you draw a circle around that, and there really is probable cause to think that every single person in that circle is either the murderer or the victim, then maybe the government can say there's probable cause that every person whose data is exposed to the government in that case will have relevant evidence. That's not the case here, where the geofence encompassed the bank and the church, and in fact, most of the 19 people were just sitting at church the whole time. So that would be a narrower way to invalidate this warrant that wouldn't necessarily impugn all geofence warrants like this one.
Thank you.
Justice Gorsuch?
So if in this case the geofence had encompassed just the bank, perhaps?
Right, so I mean, as the court knows, we still think there's a general warrant. We still think that everyone's storage lockers is being searched. And we also think
There might be probable cause to think that everybody in the bank might have some information.
Right, that's right. If you can draw it a small enough geofence at a small enough time interval that everyone there either committed the robbery or witnessed it, then you might say there's probable cause that everyone has relevant information. I still would say there's a particularity requirement. I'd still talk about a general warrant, but yes, that defect in the warrant wouldn't exist in that.
Right, and Google can track you down to several feet, right?
That's right, correct, 3 meters.
Yeah, and then in terms of the timing and on the search side that we've discussed, the fact that the government peeks in your mail for just a quick second or looks through your safety deposit box or your hotel room or your diary for just a minute, that's a search, right?
Yes.
Under either property or a reasonable expectation.
That's correct.
He's only interested in property. This was
for a
his.
minute about the Stored
He's one of the ones
Communications
who's
Act
like.
and the government's responses to your arguments.
So we believe that a warrant was required under the Stored Communications Act. We didn't file a motion to suppress on that ground because suppression isn't an available remedy, but that may be pertinent to the question of a reasonable expectation of privacy, because people have an expectation the government will get a warrant if there's a statute that requires the government to get a warrant, and there's also a private cause of action on the table.
But
the government takes the position that possibly the Stored Communications Act doesn't require a warrant because the cell phone is a tracking device. I mean, if that's true, then anything that's transmitted from the cell phone into storage, your email if you're sending it from your phone, or a photo or anything else, all of that would be information transmitted by a tracking device, and none of that would be protected. So I don't think that's a tenable way of getting around the Stored Communications Act. And so precisely because Congress has acted, and from our perspective, required a warrant, and in fact, in this case, a warrant was obtained, albeit one that we don't think complies with the Fourth Amendment, I think that weakens the force of the government's argument that we should defer to Congress, because Congress has actually said that a warrant is needed here. And, implicitly, we think the Stored Communications Act requires a warrant that complies with the Constitution, and in this case, in our view, it did not.
How about the question of whether it's content versus a record?
So the government hasn't disputed that this is content, it's not metadata, it's not a record, because the content at issue here, it's not just something about a communication, like I was in this place when I sent this email.
It is the location.
It is the location. Like the reason you're transmitting this to Google is for it to store where you were in order to create your timeline. So this is content, and the government actually doesn't dispute that in its
And talk to me about Virginia and other similar statutory laws in this area.
So Virginia has a statute, the Virginia Computer Crimes Act, that defines data on a computer network to be a form of property. It creates criminal liability for trespasses. It also creates civil liability for malicious trespasses. And so, we view the question of whether a property interest exists to be one of federal law, like the court held in the Tyler versus Hennepin case. The court should consider a common law rule, not state by state. But I think state law is a pertinent input into that ultimate federal question. And the fact that Virginia and many other states have explicitly recognized data as a type of property and have created statutory torts for trespass on that data is, I think, pertinent to the Fourth Amendment question.
Okay, now, we could bypass the search question if we just resolve the case in your favor on one of the particularity grounds, right?
Well, I think the government would say that if it's not a search at all, it didn't need a warrant in the first place.
If we assumed it were a search
That's
without
right.
deciding, we could just decide it on particularity grounds. And you've talked quite a lot about step one particularity problems you see. Can you talk about the particularity problems you see at step 2 or step 3?
Sure. So I think the problem at step 2 and step 3 is that the government conducted these follow-up searches, right? So they got an extra hour's worth of information about 9 people, and then they de-identified the people. But the warrant did not identify those people with particularity. It didn't even identify a means for the government to find those people. All it said was the police are going to figure out the really suspicious people, and they're going to do those extra searches. So the government says that the original warrant was a sufficient basis to de-anonymize and get the 2 hours from everybody in the geofence.
I've never figured out
that's
what the
wrong for a
difference
couple
is
of
between
reasons.
state and
One
common law.
is it's just clearly not probable cause to get 2 hours of information, including data outside the geofence, merely because someone was like sitting in church within an hour of the crime. And second, even though Geofence Warrant itself doesn't authorize that, it doesn't say the police can go ahead and collect data from everybody. All it says is that once the police winnows down the 19 or however many there are to some smaller number, then it can collect additional data. But that's not particularized because it doesn't say how to identify those people.
Would that be a narrow basis on which to resolve this case?
That would be a very narrow basis. I mean, I would caution the court that if the court resolves the case on that basis, then in future cases, the government can cure the problem here by just obtaining another warrant before step 2, which may be the answer, but that would be a particularly narrow way of resolving the case. Obviously, we have concerns with step 1 as well, and so, we believe that's unconstitutional.
Thank you.
Justice Kavanaugh?
Assuming it's a search for purposes of this
We don't know what he's
question,
going to do either
and
yet because he hasn't
that I
weighed in
don't
on this.
buy your general warrant argument, how can you overcome Zurcher for purposes of your argument that it's not sufficiently particularized, et cetera?
Okay, so I view Zurcher as answering a very different question from this case. So Zurcher holds that the Fourth Amendment permits a search of a premises of someone who is not implicated in the crime at all, as long as there's probable cause to believe that there's evidence on those premises that will be pertinent to the criminal investigation.
And here we have that.
We do, but
Okay.
what we
Keep
understand
going
to have happened here is more like a search of 19 separate safety deposit boxes rather than one single place, the Stanford University office, like in Zurcher. So I guess here would be a relevant physical.
Why do you characterize it that way? It doesn't seem that way to me. It's search of one place.
Well, the argument the government would make is that Google, like the expansive entirety of Google servers, are a single place. I think that's a pretty dangerous holding, because if the court were to reach that...
We're talking about a warrant that's sufficiently particular here. So it is a search for purposes of this question, but it really just boils down to, I think, is the warrant sufficiently particular?
Right, so if the court considers Google...
So we have probable cause, you admitted that correctly.
Yeah, location.
And it's just then, is it sufficiently particular? And it seems like Detective Hilton here, really went through a lot of the steps that should be applauded and in terms of narrowing this down, going through multiple steps. I guess I'm trying to figure out why this was bad police work to get a warrant. A lot of Fourth Amendment cases we say, get a warrant. Well, they got a warrant. And then you're saying, it's not sufficiently particular, but he went multiple steps. How many names were ultimately given to the detective?
Well, it was 3 devices, Your Honor.
3 names. So in the end, 3 names. You were talking about millions and millions, but it was 3 names.
Well, he started with...
So first of all, I'm not casting any aspersions whatsoever on Detective Hilton. There's no sign of any kind of malice whatsoever. That's not our argument today. Okay. We do think that the warrant was defective, and if I could just make a couple points about your questioning. So first of all, I understand a warrant was obtained here, but the court should be realistic about how much protection the warrant requirement really provides in a case like this. Sorry, Your Honor.
Well, that's what the Fourth Amendment says, so
I know.
Keep going.
Right, so the warrant requirement...
The Fourth Amendment's a floor, not a ceiling of protection, and the warrant requirement, we have to stick with the words of the Fourth Amendment and the history of it.
All I was going to say is that the government obtained a warrant merely because someone was holding a cell phone near the scene of a crime, and if that's enough to obtain a warrant, it's going to be obtainable in a wide number of cases. That's not just a factual quirk about this case. That's many cases in which this type of warrant is obtained. But I'm happy to stick with the warrant.
Geographically and temporally limited, though, the warrant.
Yes, but the Fourth Amendment...
In a way that the magistrate, a third party, not the executive, not the law enforcement, will neutrally review and oversee, and lots of times judges will force the warrant to be narrowed, right?
Your Honor, the Fourth Amendment requires particularity as to the place to be searched. In this case, the geofence was not the place to be searched. The place to be searched was these Google accounts.
So suppose we have a murder and we know, all the police know is that the murder was at a restaurant, a particular restaurant. And so the search is for, the request is for everyone who dined at that restaurant in a 2-hour period and for the names of those people. Thoughts?
So if the court doesn't buy the argument about a general warrant,
Correct.
okay, then it is possible that you might say that there's probable cause that people who were actually witnesses to the crime, they were at the restaurant when the crime was committed, you might say there's probable cause to believe that there's relevant evidence in all of those people's accounts. Here, we don't have that. So first of all, I view this as a search of—
Well, let me ask,
Yes.
alter the hypothetical, or maybe all you know is the murderer was in the restaurant, and the search warrant or subpoena, the search warrant is to the restaurant for the list of people, who were in there in a 2-hour period.
That is perfectly fine. A subpoena or even a search warrant could be issued—
And that's different from this, how?
That's right, because we view that as not a search of one entity's property, like one single piece of paper containing a list. We view this more as a search of 19 different people's private papers. Ultimately, the question is the Fourth Amendment.
You only got 3 names, but
well,
and do you agree? You agree with Searcher,
Well, that was
though? There's nothing
after
from
they
Searcher
determined
you're
who they
asking,
wanted.
including the footnote. There's
First,
nothing
they
from
went through all their
Searcher
property.
you're asking us to depart from.
correct.
Okay. And you had, this is just more practicalities, but the local government amicus brief and the 31 states amicus brief, which has a huge spectrum of attorneys general on that amicus brief, which I think warrants note, talk about the practical consequences of not being able to solve murders. A lot of, a huge percentage of murders are never solved, for example, and violent crimes. Just want you to respond to that.
Sure. So first of all, we're not suggesting that all law enforcement techniques that allow the police to determine everyone within a particular area are inherently unconstitutional. We think this particular technique of serving geofence warrants on Google and requiring searches of the sensor vault, we do think there's a constitutional violation there. But there's many other law enforcement techniques that deploy modern technology that would not present the same types of issues. And the other point is that—
Such as?
So we haven't taken a position on the constitutionality of tower dumps. That presents a very different set of issues because that cannot be conceptualized as the search of lots of virtual storage lockers. There are other Fourth Amendment arguments on the table there, but I don't think anything the court says in this case would impugn the constitutionality of tower dumps. Similarly, I don't think anything the court says in this case would impugn the constitutionality of things like taking security videos, CCTV, and using those to identify suspects. So there are a lot of other law enforcement techniques that are available to solve crimes in which you know where the crime happened, but you don't know who it is. And we're not challenging those, we're just challenging this one unique particular type of method. And the other thing is, Professor Kerr's brief points out that there's actually quite a lot of geofence warrants that have been issued. Like the district court says there was 9,000 geofence requests issued to Google in 2019. And there's actually a fairly small number of reported cases involving motions to suppress. So it seems empirically that most geofence warrants just ensnare innocent people because I guess maybe criminals turn off their phones when they go commit bank robberies most of the time. And so, the law enforcement benefits of this particular technique, I think it's easy to overstate, even though obviously in this case—
Well, the local government brief disagrees with you on that, but
Well, there's a lot of amici—
And they have specific cases, but I'll leave it there. Thank you.
I think our side has some philosophical diversity from the amici as well. So I think both sides have a lot of people with different views on this.
Thank you.
Justice Barrett?
Mr. Unikowski, would there have been a Fourth Amendment problem if the police had purchased this data from Google?
I don't think the police could have theoretically done that.
Why?
Because Google's policy is that it doesn't sell this data. It has a pretty strict privacy policy where it doesn't give the data away unless—
But it could. I mean, I'm just looking at the policy, and it says that Google may share non-personally identifiable information publicly and with our partners, advertisers, publishers, rights holders, specific partners to collect information from your browser or device for advertising purposes?
Right. No. So Google shares aggregated information, like how many people searched for the word YouTube last year and things like that.
But doesn't it share location information too? I mean, I feel like I get ads when I'm in particular places. I mean, I need to check my location services settings, plainly.
Yeah.
Not that I'm
We
going
all
to commit
do.
crimes, but it seems to me
I
like
suggest
Google—
you have IT do it.
it does seem to me like Google does give your information away.
My
I
fault,
don't
I
think it
kept you up
does. I
late.
think there are other
Okay, well,
less
maybe it
scrupulous
doesn't
apps.
as a practical matter, but that policy, as I read it, does permit Google to do it.
I don't think it does. There's declarations in the record that says that Google doesn't do it, and the privacy policy says that it's not going to share individual data with advertisers. I think what you read is not a reference to location history. I'm not sure what, I don't think it is, Your Honor. There's a declaration in the record, and there's live testimony, and there's a statement in the privacy policy that Google only does not share individual data with advertisers. It just doesn't do that. Like, an advertiser cannot go to Google and say,
Okay, what if it did? What if it violated its own privacy policy and allowed the police to purchase it? Isn't that a problem between, like, the person who has the Google account and Google? Would that be a Fourth Amendment problem?
It might not be a Fourth Amendment problem because there's like the private search doctrine. Even if someone unscrupulously but privately takes someone's data and illegally gives it to the government, you might call that a private search.
But doesn't Google have, I mean, I guess what I'm getting at is, doesn't Google have some right? I mean, Google can dip in and dip out, at least under the policy as it existed at the time this search, or this possible arguable search occurred.
We view this as just like FedEx. So if you look at the FedEx privacy policy, FedEx says it reserves the right to inspect packages when it needs to do that. But I don't think that means that the government doesn't need a search warrant to inspect packages. In the same way that if you stay at a hotel, the hotel reserves the right to have a housekeeping service come into your room, and maybe the housekeeper will see your personal possessions, but that in and of itself is not consent to have the government do that. So likewise, yes, Google does reserve the right to analyze your data. Like if you went to a lot of ski hills, you might see a ski ad on YouTube, but I don't think that in and of itself meant you've waived Fourth Amendment protection with respect to the government seizing it without a warrant. I mean, if Google sold it, I don't think Google's even capable of that. If Google just voluntarily handed the data to the government, that might be a little bit more like the Jacobson case, but I don't think that's what we have here.
Thanks.
Justice Jackson?
By the way, everybody, if you don't mind,
I guess I
the end of the month, so I gotta
see you as making
please consider
maximalist
hitting my
arguments
Venmo.
about this in ways that I'm trying to understand if they're necessary to get to the point where you want to go. I mean, I thought the key issue was what makes a warrant for a search of this nature sufficiently particularized. That's one way to put it. And so, first of all, we've got Google responding in steps. We have this warrant
Gustav, that's
request.
super
The
on point.
officer, according to your brief,
No, Vashon.
identifies a geographic area based on where the crime took place and the time. We have a bank robbery at X time. So what I'd like, says the law enforcement officer, is the location history data for 30 minutes before to 30 minutes after a 150-meter radius around the bank. Is that right? Is that how it starts? Okay.
Yes.
And as Justice Kavanaugh points out, at the end of the day, they end up with 3 names. But we have a lot of steps.
Thank you,
in
Maxwell
between
and Leah.
under Google's iterative process for giving the officer this information. So I guess what I don't understand is why you aren't arguing something about needing more probable cause as each one of these steps goes along. Yes.
I do think that is one of the arguments we're advancing today, that the government did not obtain a fresh warrant before it conducted the Step 2 search, and the initial warrant did not authorize all of the information to be obtained, from all of the 2 hours of information to be obtained from everyone within the geofence.
Right.
Yes.
Okay, so fine. But why isn't there probable cause? You seem to be fighting the premise that at the beginning, when the search is drawn, when the fence is drawn, 150 meters around the bank, 30 minutes before and 30 minutes after, and 19 accounts are identified, setting aside your general warrant point. Mm-hmm. You seem to be suggesting, or you're arguing, that there isn't probable cause to do anything more at that point. That something about the 19, they have to know something about a particular account. I don't understand that. Why isn't it enough to begin with to just ask as the magistrate, is your fence reasonable? Is the 30 minutes before and 30 minutes after, is a 150-mile radius? Like, why isn't the step 1 probable cause inquiry just, do we have a reasonable scope to begin with? I would think that we would just ask that, and that the answer in this case would be yes.
Well, except for that very last step, I don't disagree. I think the answer in this case would be no.
So what's wrong with 100? Is that too wide? Is that too big? Why is that too big under these circumstances?
Well, the problem is that we view what happened at step 1, even before the de-anonymization happened, we view that as a search of people's private papers.
No, I understand.
And so
and
if that's...
You said in response to Justice Kavanaugh, it's not the whole location. Justice Kavanaugh says this is Zurcher, which I think has some force to it, that we have a location and there are maybe 18 people in this 19-person search who are going to be innocent, who didn't know anything about this, but just happened to be there in that time. But Zurcher seems to say that's fine, as long as you have probable cause to believe that there is a crime that's being committed in this location at this point. You say, no, it's each person's individual count. If we disagree with that,
Okay.
all right, if we think this is Zurcher, then why is 150 meters or 30 minutes before or 30 minutes after unreasonable at step one?
Okay, if you think it's just like Zurcher, I still think it's unreasonable at step one, because I think the geofence warrant covers people who are just sitting in the church the whole time. And I think that geofence warrant that encompasses not just the bank, but also a church and a church parking lot 30 minutes before and 30 minutes after.
But we can't eliminate those. We don't know anything about those people. This is a reverse warrant, says Professor Kerr. You're allowed to have the radius encompass people who aren't necessarily the bank robber if you're trying to find the bank robber and there's probable cause to believe he was there 30 minutes before or 30 minutes after. You don't eventually get those people's names. That's the point I'll get to. But for step one, I don't understand why there's a problem.
I guess that's the question, whether it's okay under the Fourth Amendment to say, well, we don't know which of those
only
people
5
it is,
likes
so we're
on
just going to
YouTube.
search
Come
all of them
on.
to try to find the suspect. Because that's essentially what happened here.
Okay, so isn't the real problem, if you're looking at it as I am, that the point that you made with Justice Gorsuch, that we don't understand how the police went from the 9 to the 19? That the next step in opening it up and looking for more information, there has to be some rational basis or probable cause to believe that these particular accounts we need to have more information for. And that's not in this record, right?
That is certainly true, Your Honor. The warrant just told the police, basically, find the people that seem most suspicious to you. And the police just initially selected all 19. Google pushed back. The police selected 9. But the warrant itself doesn't provide any criteria. And
if it did, would it be more particularized? And isn't that what we should be saying in this opinion, for example?
well, that would be a different way to achieve a Fourth Amendment, to rule that the Fourth Amendment was violated. That would be a very narrow resolution of this case. But yes, I do think that that alone is a sufficient basis to invalidate this warrant, even if the court disagrees with our broader arguments.
Thank you.
Thank you, counsel.
Is that it?
Mr. Fagan?
Thank
All
you,
right.
Mr.
Once again,
Chief
everybody hit
Justice,
like,
may it
everybody
please the
share,
court.
get it
As
out
I
there,
think
get people to...
Justice Jackson was just getting at, petitioner here is asking for an unprecedented transformation of the Fourth Amendment into an impregnable fortress around records of his public movements that he affirmatively consented to allow Google to create, maintain, and use. In doing so, he would make that fortress so impregnable that not even a judge's warrant for even a moment of the public location of someone who, again, affirmatively opted to allow Google to have those records and to access them would be available to law enforcement. That's a debilitating and counterintuitive reading of the Fourth Amendment that would impede the investigation of kidnappings, robberies, shootings, and other crimes, and would implicate any number of practices that I think opposing counsel kind of just waved his hands about, like tower dumps. Frankly, Mr. Chief Justice, I don't know how he concedes exigent circumstances, because under this court's recent decision just this term in case against Montana, we need reasonable cause to believe that there's a necessary search, and under his view, this would be a search of everyone who has location history stored with Google, and I think he would have to say that we don't have reasonable cause as to each one of those people. And the way he is trying to achieve that counterintuitive result, I think, rests on two fundamental misconceptions that have been emphasized this morning. One is that this is like uploading your own content to a storage locker. Even Google doesn't treat it that way. If you see it, if you look at Joint Appendix 55, you'll see that Google separates out user-created content from other kinds of content. The second main misconception here, if I might just continue for 1 second, is that this would implicate all sorts of other types of data in which the court has found more of a reasonable expectation of privacy, like email. Location history is different. I'm sorry, Justice Thomas.
Mr. Fagan, would you address Justice Alito's point as to this being an advisory opinion?
Frankly, Your Honor, we attempted to warn the court about that in our brief in opposition. If the court wishes to dismiss the case as improvidently granted, we'd be fine with that. I do think there's really no chance the opinion here would make the officer's actions here unreasonable. Petitioners suggesting now some kind of new kind of warrant requirement exception to the good faith exception. I don't really understand how that would work or what the contours of it would be, and I don't, like, what does it mean to have a new kind of warrant? At bottom, we just don't think there's anything that's going to happen here other than an affirmance. So you would essentially have something that looks like an advisory opinion. I mean, I suppose the court could say that the theoretical chance that something might happen is enough to keep this case alive, but I don't think that makes a great deal of sense.
Additionally, the
Thank you, George, John, and Jordan for the
Google's
Venmos. I appreciate it very much.
changed,
I'm going to keep going. Thank you.
Would you compare that policy to this
Anybody
and
wants
the
to?
effect of that change?
Do you mean the pushing out of location
Yes.
history so it's now stored on the phones?
Exactly.
Well, I don't know that it would make a Fourth Amendment difference if Google were still able to comply with these warrants. But Google has represented to us that as of 2023 and that change that it made, it is no longer able to comply with the warrants, and that makes the difference. But I'm sorry, Your Honor. But otherwise, if this were information that were exposed to Google, I think it's an important feature of the warrant here that Google is actually the one doing the filtering on Google's accounts. As to any account except for the 19 that were additionally returned, and of course they were all anonymized, and they were truly anonymized. Their expert, if you look at page 288 of the Court of Appeals Joint Appendix, admits he wasn't able to specifically identify even the 3 people he was talking about. But as to everyone else other than the 19, they might as well not have existed from the government's perspective. And even Google didn't really learn very much about them other than that they were not within this 150-meter radius circle during that particular hour.
Yes.
I question whether that is an invasion of their reasonable privacy expectations. I think clearly not under this court's decision in Knott's. That's a public place. These were public movements.
Counsel, if I could interrupt.
Sorry.
One of the central concerns that's been voiced, of course, is what's to prevent the government from using this to find out the identities of everybody at a particular church, a particular political organization. What are the restraints that would prevent that from becoming a problem?
Well, number one, Your Honor, would be the Stored Communications Act, and I respectfully disagree with Petitioner's counsel. I mean, we have a somewhat different reading of the Stored Communications Act and exactly what it would require under these circumstances, and I know it's a statutory protection, but I disagree with counsel that it sets some kind of Fourth Amendment floor. The court basically rejected that position in City of Ontario against Kwan, which also involved the Stored Communications Act.
Well, put the statute aside, just in terms of the Constitution.
Putting the statute to the side, I mean, first of all, I don't think that there's any kind of categorical protection around something like a church. I mean, unfortunately, as you saw with Dylan Roof, we can have a shooting at a church. If he'd gotten away, I would have thought this would be a law enforcement technique.
So you don't think there's any constitutional protection from such organizations to be subject to focused surveillance that would cover everybody in the particular location?
Well, I think one avenue that the court has potentially held open, number one, is the amount of time for which the government could look. I don't know that the government could see everyone who came into a church at any time.
Well,
but
if the services start at noon, they can go from noon to 1, however long they take.
So let me make a few points on that, Your Honor. First of all, someone doesn't want it known that they're going to a particular place, like an abortion clinic, for example. They don't have to enable location history or keep it on while they're visiting that location. I mean, if there were a surveillance camera at a bodega across the street from the church, that could also see everybody who came in, and I don't think there'd be a claim to Fourth Amendment protection from government review of that. The second thing that I think I would say is that this has
Thank you,
been
Anthony.
the degree to which someone can really be located in a particular location, I think is somewhat overstated in this case. If you want to look at the sealed volume of the Joint Appendix Volume 3, you'll see that usually there's a fairly wide confidence interval of close to, like 30, 40 meters for everyone. So, and that's only, that only describes a circle with a 68% probability of containing them. So it's
Well, but
difficult
I don't
to know
mean to-
exactly where they are.
I mean, we can't rely entirely on good faith, but the point is not that they're looking for a particular individual, but they want to have a catalog of the people who go to a particular location. And it seems to me that that's a realistic problem.
Well, Your Honor, first of all, I mean, that can't really happen under the Stored Communications Act.
Well, again,
And the
put the
second-
statute to one side and just focus on the Constitution.
Okay, and the second thing I'd say is, I would focus on this particular case, and in every case in which this has come up, the government has gotten a warrant because Google, it's just easier to get Google to comply if we do get a warrant. And if you want to put the warrant aside, Your Honor, I do think that what really matters here is that people have affirmatively opted in. Only 1/3 of active Google account holders do that.
So to prevent surveillance of sensitive locations, you have to rely on the fact that people are going to turn off something that many, if not most people, find is an important service.
Well, Your Honor, I do think if you wish to conceal that you are at a particular location and you are effectively shouting and broadcasting your location to Google, and that Google is creating, maintaining, using for any number of its own purposes those records. I mean, Google could send you an ad saying, hey, I see you go to...
Mr. Fagan, I'm
sorry.
sorry to interrupt, but I got to think the answer to the Chief Justice's question is yes. This isn't a search. We don't think it's a Fourth Amendment search at all. You don't need a warrant. And yes, if we want to determine everybody who is at a church or a political rally or the abortion clinic or anything else like that, we can do that, as long as we can get Google to comply. Oh, and we might have a few tools besides warrants to get social media companies to comply with governmental requests.
So I do think that effectively is our answer, Justice Gorsuch. I'm not walking away from it. I'm simply noting two very important features.
I understand that, but that has to be your answer. And then there's a little tension in your argument as well. You're saying the sky will fall if you can't do this. That you started off with that. That was the very first point you made, how important this is.
Did he just say we
in the
don't
next
need a
breath,
warrant?
You said that Google can no longer provide this information because it is reconstructed how it operates. Can both things be true?
Yes, Your Honor.
Did I hear that right?
Here's
Somebody?
why. I think a lot of the arguments that are being made here today and are made in the briefs, if accepted, and I think, again, this is something Justice Jackson was getting at, would have a debilitating effect on a number of other law enforcement techniques.
Like looking at email.
So email, Your Honor, we get a warrant for email.
But again, you don't think you need one because they broadcast it, as you say, to Google. It's subject to very similar terms of service.
That's not correct, Your Honor. We view email differently, and there are several reasons.
How about Google Documents? How about photos?
We view all of those
So it's
differently, and there are
just location data that's different?
Yes.
Okay.
And this court has made clear that it's different. So in Knotts, the court makes clear that...
Could you just footnote that answer? Are they different because you treat them differently, or are they different because something in your theory doesn't apply to them?
Your Honor, I was just getting to that. So we think they're different because the court has always treated like the contents of one's personal thoughts as recorded differently from one's exposed public location, which is all that's at issue here. At least
How about a calendar?
So your calendar, I also think, would be different from your location history, because a record, your own personal updated calendar of where you've been. And there are several reasons for that. I think the court has made clear in Knotts that exposing your public location for 2 hours, you don't have a privacy expectation in that. And that contrasts sharply with cases like Ex parte Jackson about physical letters, or even a case like Katz, which
I
is about
interrupted
telephonic
Justice Gorsuch, and
communications. Second, I think that's consistent with the original understanding of the Fourth Amendment. Justice Thomas gets into this a little bit in footnote 8 at page 351 of his opinion in Carpenter. About how the original focus of the Fourth Amendment was protecting personal confidences.
he was a dissent there, though.
On this particular point, Your Honor, I don't think there was.
Yeah, but Mr.
it was
Fagan, I do think
inconsistent
that
with what the
Carpenter
majority-
seems quite relevant to this. What you're now saying is location is different from email and photos and calendar appointments and everything else that people give to Google. And the reason is that location is just different because people just think that everybody knows where they are all the time. But I would have thought that Carpenter had something to say about that.
So one point, and then I have 3 different reasons why this case is different
wants
from
Carpenter overturned.
but, well, let me just jump to the 3 reasons, because that's what you're
He
asking
wants Carpenter
about.
overturned.
Number 1, we did exactly what Carpenter instructed us to do in this case. We got a warrant. Number 2, I do think Carpenter and Jones.
But you're saying you didn't need a warrant. So, I mean, I think the question is your theory, not what you did
Okay,
out of the goodness of your own heart.
Putting the warrant, which I think is the easy way to resolve this case, to one side. I think there are 2 key distinctions between this and Carpenter. One, in Carpenter, you had essentially the creation of CSLI, cell site location information, as the price of even
Cell site
having
location?
a cell phone, which the court had said in Riley was a device that basically nobody can live without.
That's the one where it
That's not the case
pings.
here. You have people
Is that the standard, that nobody can live without this standard?
That's the one fixed point that the court has given us. But here we're a long ways away from that, because even 1/3 of only 1/3 of active Google account holders bother to enable location.
So where's the line if 80% enabled this? Would that make it a different case?
I think that would be much closer to Carpenter, because I think, if I'm recalling correctly from Riley, it's something like 90% of people have cell phones. But I certainly think 1/3 of active Google account holders, which is a fairly small percentage of the world's population overall,
There's your argument.
shows that people don't need this. You can use Google Maps without location history. You can use Google Maps even without a Google account. The second thing I would say about Carpenter is that although neither Carpenter nor some of the separate opinions in Jones, like Justice Alito's opinion that you joined, drew clear temporal lines, I do think both Jones and both the opinions in Jones and Carpenter focus on detecting the patterns of life and long enough periods of location to show the patterns of life. I don't think 2 hours is enough to show the patterns of one's life. They might show that you went to a church once. It doesn't show that you're a regular churchgoer. It might show that you went to a doctor's office.
I guess one
It
question
doesn't
would be,
show
why is it, why would the only thing that you would have an interest in protecting is the patterns of one's life, as opposed to the things that you do in one's life that you particularly don't want people to know about, such as going to a political event, going to an abortion clinic, etc. It's like I can tell you a lot of things about the patterns of my life. What I really want to keep private is particular things that I might do, on very discrete occasions.
Well, 2 points, Your Honor. One is, I think the fundamental insight of Knott's is that if you walk out in public and you walk into some sensitive location, then you are exposing all of that to public view. In Knott's, they were following people to private residences. They didn't follow them into the private residences, but they were following people to private residences through the use of a beeper and stopping outside the private residence. Maybe you don't want someone to know that you're having an affair, but if you have a beeper in your car under Knott's and they're following you for 2 hours, they will find that out.
Would your position be the same if you had picked up Mr. Chatrie in his home?
If
If it
there's
had
testimony
revealed
at page
his-
120 of the joint appendix from this court that shows that we couldn't locate which of the houses was his, even though he eventually did go to a house, because, as it turns out, because the confidence intervals were simply too
But your position would remain the same, regardless whether somebody was in his home at the time.
Well, Your Honor, I guess I would make a couple of points. I think that
I heard Jones' case, I don't
we
know.
would
Or
argue
Katz.
that. I think the court could draw a distinction. And the reasons we would argue that it would still remain the same is, number one, we had no warrant. Number two, I think this would make this case somewhat like Caro, where it doesn't invalidate the law enforcement technique ab initio. It just means that someone with standing could suppress the information about the particular home. And number three, I think this is distinct from other home circumstances precisely because of the opt-in and the fact that the person is advertising the fact that they are at home, sharing that with Google, and Google could say, you know, Google could say, I see you go to church every Sunday, maybe you'd be interested in this particular religious item. Google could say, I see you're often in the house on Saturday mornings, maybe you'd be interested in this particular thing that could be delivered to your house on Saturday mornings. And so they are opting to share that information to get a purely voluntary service, and they're doing so, if you want to look at the terms of service, which we agree aren't controlling, subject to the full knowledge that Google, of what Google is doing with it, and the ability of Google to respond in good faith to law enforcement or to make any number of other choices, like sharing with service providers, for Google that will expose that information to public view.
You're really saying, I mean, you're leaning pretty heavily on the correct proposition that what you do in public view is not generally, you don't have a reasonable expectation of privacy in, but now you're telling Justice Kagan really that if you go into a private home, it wouldn't be a search? I mean, if you trace location services, I mean, I understand in this case, and is that true that in this case, you're saying you didn't pick him up in any home?
Well, Your Honor, he eventually stopped at the end of his journey away from the bank at a group of homes, but there's testimony, this is page 120.
But not
of the joint
inside
appendix.
the home?
We couldn't tell which home he was even in.
Okay, but you really are saying that you could track someone going inside a home. Justice Sotomayor asked Mr. Unikowski about movements inside a home, movements to the bathroom, movements to the bedroom, all of that, if the confidence interval is narrow enough.
Your Honor, I think what I'm saying is two things.
How are you gonna
One, I do think
tell?
we could have done that here because of the warrant. Like,
Okay, but I think the question is
under
that a
Carroll.
search under your?
Is it a search? I think probably, Your Honor, like, I acknowledge that's going to be a much harder case for us.
But no,
I think
is
if we
your
were to
answer.
argue that, I think I'd like to reserve the possibility that we could argue that it's not a search principally because of the opt-in and the broadcasting. But look, I fully accept that that would be a very, very difficult argument to sustain. Nothing in our argument in this case depends on it. And I'm not like saying that's critical to our argument. And if the court thinks that that is a bridge too far, I'm fine with that.
Well,
I was just having
except for it's
the,
totally inconsistent with
proposition.
your theory, but other than that.
Other than that,
on-
Justice Gorsuch.
On the particularity side, Mr. Fagan, let's say you go to a hotel, and the warrant is search all the rooms in the hotel for the gun on the bedside, or the storage facility, search all the storage units for a particular contraband, or to the bank, go search all the safe deposit boxes for the pearl necklace that's been stolen. What's the difference between those cases and this case, assuming that I have a term of service with the hotel, with the storage facility, with the bank, that says you can access these places from time to time for purposes that we agree upon, and of course, you can do something with the government if the law allows it.
So, Your Honor, I think this goes to a somewhat under-theorized portion of the Fourth Amendment, which is the definition of a place. I think we often have an intuitive sense of what's a place. In particular, with an apartment building, I think
You would agree those warrants would all be impermissible?
I don't know necessarily about storage locker one. That would probably be impermissible. Certainly, we couldn't search every apartment in a building,
Wheeler, for
both
Cash
because
App.
homes are first among equals and because
Hotel rooms, bank safe deposit boxes, storage facilities, the warrants I've just described, go search for the contraband, the gun, the pearl necklace. Okay or not okay? Are those sufficiently particularized?
Well, let me take them each in turn, because I think the analysis might be slightly different under each of those things, Your Honor. First of all, for the apartment homes, no, and I think that's...
Still haven't asked about apartments, asked about hotels, but
I'm sorry, a hotel is the same, because the court's treated it as a home.
Okay.
And houses are specifically listed in the Fourth Amendment, and they're
All right.
first among equals.
How about the other two?
Okay, I think storage locker, I think probably we could not do that, and I think we probably couldn't do a storage room, although it would depend how it's organized.
Like every storage facility in America, you know, with one of those awful rolling gates and a padlock at the bottom.
So let me explain why that's different from this case, if I could.
Yeah, I'm just asking you, do you think that warrant would be sufficiently particularized, the one I described? Yes or no?
I think it would be sufficiently particularized because it would describe what the government had basis to search for.
The government could
But
ask
what I don't think
a storage facility and require them to search every locker and 500 lockers for the contraband.
What I don't think is that it describes a discrete Fourth Amendment place in which to search for the things that the government
So it's not
is looking
particularized then?
for. So I think
I'm
it's
really
more
just
about
looking-
place than particularization there, assuming there's probable cause to believe that the area writ large is going to contain the contraband. If I could explain a little further on this, Your Honor, I think what makes the difference in some of these hypotheticals versus what we have here.
Well, first, I just want an answer to my hypotheticals, and then we'll get to here, if that's all right with you.
Your Honor, my answer to the hotels is no. My answer to the other two is very likely not.
Okay.
Yeah, I would need to know a little more about it.
Okay, all right.
And now, let me explain why.
And now, turning to this,
No,
do you
this isn't
agree
about you.
that Google had to query every single user's?
Is that what the...
No.
Well, you said
I mean,
so on page 10 of your brief.
do you mean
page
query
41.
in the, do you mean query is like a synonym for
I'm using
search
your
in the Fourth
word from
Amendment
page
sense?
41.
Oh, okay, yes, I do agree Google had to query in that sense. I'm sorry, I thought you meant
And there are about
query as a
500
synonym for
million
search.
users' accounts, right?
Yes, I agree with that.
Okay, all right.
I agree, and let me tell you why it's different. I think the reasons the hypotheticals, but I apologize for misunderstanding your use of query as a synonym for search. The reason this is different is I think it's a lot
Did
about
he just laugh at him?
opacity and control. And what I mean by opacity is the separateness of the different spaces. And control is who has control over those spaces. Here is a case where I think, as the court recognized in Riley, can often happen, the
Gorsuch just
physical analogies
snorted.
kind of break down to some degree. The court has been clear in Smith against Maryland.
Well, let's just stop there.
Yeah.
Let's assume that these accounts are kept in, you can call opacity or whatever you want, but are kept in the same kind of discrete manner as your email is.
Well, Your Honor, I don't think that's the case here. I think
Let's
what's
assume it is. Let's assume it is. Let's assume that the Google user account, we've got a lot of briefs on this,
So, Your Honor,
they're categorized similarly by user and walled off from other users, both the email and the location data. Let's assume they're similar in that respect.
Your Honor, if this were a record that the user created and uploaded, our answer to this case would be different. But in this case, this is a record that Google creates, Google software sends it, Google processes it, it runs its own algorithms to actually figure out what information it's storing. It is data that Google maintains and data that Google accesses for any number of reasons. If we were to have a physical analogy to storage lockers, and I'm not sure how useful these physical analogies are, it's like having a bunch of storage lockers where there's a glass wall in front of them instead of having an opaque door for each box. All the government is asking for here is to get in the room and look at the front of those storage lockers. I don't think that the limited amount that even Google sees at step 1 is going to be considered a search. And for, as I said earlier, from the government's perspective, all of those other storage lockers, if you want to call them that, and we're accepting that analogy for purposes of this answer, all of those other storage lockers might as well not exist. For all the government knows, there are only 19 people who have their location history.
Mr. Fagan, is that because at step 1, unlike the examples that we've been talking about, you don't know how many apartments there are. You don't know how many storage lockers there are. At step 1, it's just like getting a list. There are 16 apartments in this building. Right? And that's why I'm appreciating a difference between the steps as the iterative process with Google goes forward. Step 1 is we have a bank robbery. Here's the bank. We would like to know how many cell phone accounts were in this radius during this period of time. Right? I mean, you don't have the names, you don't have anything more than that. I'm struggling to understand the step 1 problem, other than to figure out how the government came up with 150 meters and 30 minutes before and after. So can you start maybe by answering that question? Where does that where do those numbers come?
I can't help your struggle with step 1 because I too don't see a problem with step 1. But the 150-meter radius and the half an hour before and half an hour after were based on wanting to exclude, there's some testimony in the record about this. They did want to include the church because they had testimony about a suspicious car that had been parked at the church, and they thought the robber, as it turns out correctly, might have come from there.
So evidence was presented to the magistrate. The reason why we're making the circle this big to include these structures is because there could be some connection to this robbery.
I don't believe that evidence, that particular reason for including that was presented to the magistrate,
Okay.
no. I'm just explaining to you how they got 150 meters, and half an hour before and half an hour after allows you some information about, for example, there was a reference, and the magistrate did learn this, to co-conspirators in the demand note, and you might want to see if someone dropped the robber off or someone picked up the robber afterwards. You want to know more about the movements around it. The advantage the magistrate has that I think is difficult for a reviewing court to replicate is knowledge of local conditions and realizing that 150, if I could just finish the sentence, Your Honor,
Sure.
150 meters in Midlothian, Virginia isn't likely to turn up the entire phone book.
Thank you, counsel. Justice Thomas, anything further?
Jack,
Justice Alito?
not exactly, because
You've
one would
been
have come
asked
from the
quite a few
legislative branch. They
questions
wrote a law. It's sort of
that
unrelated.
analogized what happened here to searches, old-fashioned searches of physical places. So searching the room of everybody in a hotel. If that happened, I think there'd be an awful lot of angry hotel guests, all of those who had nothing whatsoever to do with the crime. Here, Mr. Unikowski says 500 million people were injured when there was a search for their data, even though it was completely anonymized. How many of those 500 million people have come forward to complain about anything like this?
They don't know.
Which may be going on every day.
Well, I think that's right, Your Honor. I think that points up that if they did want to complain, that would be the separate Fourth Amendment standing question, of course, and I don't think that petitioner here can represent their standing, but one reason they wouldn't complain is, first of all, I don't think this would violate the reasonable expectations of privacy, even if the government were doing it. Second of all, Google was doing it, and it's no different from any number of other things that Google does for its own particular purposes.
Well, don't you think that makes a difference for Fourth Amendment
So if they
purposes?
snuck in and searched all the hotel rooms without telling anybody, that'd be fine?
Officer invading a physical space and a request to a company to conduct a search with which the company complies?
Right,
well,
ICT
not
guy?
only
Do
do
we
I
all
think
need to-
that, Your Honor, but I think the court has said that multiple times. If you look at cases like Oklahoma Press against Walling, or lone steer. It's very different when an officer comes into the premises and looks around versus something that functions, although this had the protections of a warrant, in many ways it functioned like a subpoena in that it was the provider doing the filtering and the provider disclosing the records, which limited what the government saw considerably. The only non-anonymized information the government got was for 3 individual users. It didn't know anything about anyone in the sensor vault other than the 19 that were returned for step 1, and as to them, it didn't know their identities.
Somebody please hold it.
So I do think that's critical. But the argument that he's trying to make about step 1, I think it's very important that it really does implicate tower dumps, for example, because it implicates any number of law enforcement techniques that might incidentally find data about someone else. Even a CSLI warrant, you might have a company that organizes its data by tower.
All the towers.
And in order to find, let's call him Carpenter, in order to find Carpenter's CSLI data, the company has to search across all of its towers during the time period and figure out which ones are Carpenter and which ones aren't. It's going to learn everything about all its users, in theory. I mean, I'm sure it's using software to do this and having a filtering mechanism, just like Google did here, but it's going to learn everything about all its users for that period of time.
Only about the users that were
he'd distinguish that. For tower dumps, I don't know how he'd distinguish.
Tower dumps are not before us. Emails are not before us. Calendars are not before us. Photos are not before us. I mean, I understand that if we're going to write a treatise on the application of the Fourth Amendment to the new digital world, we might want to include sections in all of those things. But none of those things is at issue in the actual case or controversy that is before us. You've heard some proposals about
I don't
narrow
know
theories on which the case could be decided that would, as I understand them, focus on whether there was a lack of probable cause or a lack of particularity at step 2 or step 3. What would be the precedential importance of a decision like that, which turns on the particular warrant that is at issue in this case?
Well, Your Honor, unless the court upholds the warrant, I do think the court needs to reach the search questions in some way, because the court would have to address whether the warrant was even necessary. And I think, as I've tried to make clear to the court, a lot of the arguments that petitioner is making here, while those other techniques are not directly at issue, would have implications on a lot of those other techniques and would create a lot of litigation and have a potentially debilitating effect on law enforcement. But they could even affect such things as visual camera surveillance. But as to the specific question you asked about the particularity at steps 2 and 3, I do think it was sufficiently particularized because you had geospatial and temporal coordinates that showed that these people might be either suspects or witnesses, and the government simply was able to obtain enough information to figure out which of them might have information or be worth identifying. And I think the court's been clear that those are permissible law enforcement interests. The court might say that, I'm sorry.
No, let me just, I don't want to take up too much time. Let me just ask one final question. Of all of the arguments that the petitioner has raised, which do you think would be the most disruptive of what everybody has understood to be the limitations of the Fourth Amendment up to this point? His argument that this is a general warrant, his argument that he had a property interest in this data that was collected by Google, his request that we treat this search by a company as if law enforcement officers were themselves searching through records. Which is the worst?
Is all of the above an option, Justice Alito? I do think the idea that you have a privacy right or a property right and even a moment's worth of location history could be debilitating to all sorts of types of visual surveillance. The agent theory could debilitate subpoenas. The property theory, I don't even know where the Fourth Amendment goes after that. And I do think a lot of these theories are, and the general warrant theory that Your Honor mentioned, I think would call into question how we do a lot of computer warrants. We often name the servers as the place to be searched. And I don't frankly know, and I don't think courts are well equipped to find out exactly how data is organized within a particular company, and I don't know whether we have to take discovery on that in every case where we seek a warrant and actually really go down to the nuts and bolts or the virtual nuts and bolts of how a company does this.
All right, thank you.
Justice Sotomayor?
A few questions. Number one, the Stored Communications Act, a violation, Mr. Unikowski said, may be a violation, there may be criminal penalties for it, but it doesn't give a suppression remedy, correct?
That's right.
All right. Number two, you're saying everything would be horrible, but Carpenter has already said you need a warrant, correct, for data? Correct?
And we got a warrant here, yes.
All right. But you're saying I didn't need a warrant because it was a short period of time, assuming I disagree with that.
Well, Your Honor.
Just assume that, okay? There are 3 steps to this process. Were the 3 steps approved by the warrant? I read the warrant, but now I've forgotten. Were the 3 steps approved?
Yeah, the 3 steps were all laid out within the warrant itself.
But the one who made the choice at step 2 and step 3 was Google, not a magistrate, correct?
Well, Your Honor, the warrant required the government to make reasonable efforts to minimize between steps 1 and 2 and
well,
steps
usually,
2 and 3.
isn't it, I thought that if for the foreign checking system that we have, that magistrate judge says you have to minimize as you're doing it, but come back to us if you want a greater scope, correct? And here you went from 30 minutes to 2 hours, and you didn't get a magistrate judge.
That
correct?
was expressly authorized within the warrant. The warrant's parameters said that step 2 would be an hour before and an hour after the robbery.
Okay, I thought it was 2 hours. Maybe I misunderstood.
That's a total of 2 hours, Your Honor.
I see.
1 hour
All right, I
before, 1 hour
misunderstood
after.
that.
The original was an hour, half an hour before, half an hour after.
I understood, many jurisdictions in which the government is going back at step 2 and step 3, correct? That's not much of a burden. If you got in step
Your Honor,
1 and you can explain your reasons for why you're narrowing the warrant and why you need it at step 2, you could do that.
We could do that, and with more recent warrants, the government has done that. Obviously, this was a Virginia warrant. But just to defend this warrant for 1 second, I think the court recognized in Scott, which is a case we cite in our brief, which is under the Wiretap Act, not directly a Fourth Amendment case, but the same principle applies.
Now, there's value, isn't there, in our saying something like, or deciding, we need a warrant? It has to be particular as to time, place, time, and it has to explain the reasons why those limitations are reasonable, because that's always a part of the warrant search. And wouldn't that have value for the dispute that's going on around the country and between and among judges even on this court? Some said some took your position that there's no right of privacy whatsoever and you don't need a warrant. Others have taken the position that you need a warrant, but you don't need much supervision from the magistrate judge. There is value in our setting the parameters of this process, isn't there?
I think if the court were to say something about warrants, that could have value, and I'm not going to claim that the sky is going to fall if we had needed a separate warrant at steps 2 and 3, and a total of 3 warrants. We've actually done that in more modern times. But what I am saying is that I would caution the court against saying that that warrants can never include any kind of discretion, like the warrant did here.
We don't need to say that. If all we said was, you generally need particularity, the way you do in any situation, you have to give enough to say there's a reasonable probability or fair probability, I think is our language, that evidence is in a would be disclosed, and it's a limited search to these times and places, and you have to do it at each stage of a warrant.
Your Honor, I think we met all of those requirements here.
I don't even know if we need to go that far, but you would not be troubled by that rule.
Your Honor, you're simply describing what the Fourth Amendment requires, and
All right,
as
that's
we've laid out in our
exactly-
brief, we think
that's
the Fourth
exactly-
Amendment satisfies those requirements. Our warrant satisfies those Fourth Amendment requirements.
I'm not quite so sure of that, because you don't explain why it's narrow, but that's a different issue.
Well, Your Honor, if I could be...
All right.
Justice Kagan?
Mr. Fagan, I'm going to give you one of these physical location hypotheticals that you're going to resist, but you'll have a chance to tell me why it's different. But I want to understand your theory, and the easiest way for me to do it is through this. So let's go back to what Justice Gorsuch said. Let's use the storage locker. And there's a storage locker facility in town, has 500 storage lockers, and they have a relationship with the police chief, so that the police chief can come to them and ask the storage locker manager to search all the storage lockers for particular things that the police chief needs. So the police chief goes to the storage locker manager, and he says, we're looking for somebody with a particular kind of weapon. You know, we're looking for somebody with a Glock. And the manager goes through each of the 500 lockers, and he comes back to the police chief and he says, I've got a list for you. We have 8 lockers that contain a Glock. And now we're going to have a further conversation, you and me, the manager and the police chief, about which of these 8 you really want, all right? And they do that. So in that situation, how many of the lockers would you say have been searched? And how should a warrant respond to that? In other words, have 500 lockers been searched? Have 8 lockers been searched? Or have 0 lockers been searched?
I think some of that might depend on exactly the circumstances under which the proprietor of the storage facility was permitted to go into the storage lockers. Because that might set some of the parameters of the reasonable expectation of privacy, or at least inform them. I also think it's distinct from the circumstances we have here, because you actually have someone who more plausibly could be seen to be acting as a government agent than the recipient of a warrant or a
No, I guess what I'm
protection.
saying is just assume that the relationship is similar to the relationship between Google and the government, and just assume that the terms are similar to the terms that Google has with its customers. So all of that is the same.
So
500 lockers searched, 8 lockers searched, 0 lockers searched.
Your Honor, I think to the extent we're talking about physical objects that are put into a storage locker that is expected to remain locked except when the user comes and wants to take something out of it, I think we might say that was a search of all the lockers, because someone went in and looked in every single locker.
And so what would you need for a warrant for that search?
I think we'd need probable cause that there was going to be a Glock in one of the lockers, but I think...
So you couldn't get it for all 500?
I am uncertain that would be valid for the reasons I was discussing with Justice Gorsuch, in that those might all be separate Fourth Amendment places, and we'd need specific probable cause as to each. I don't think that's true of the database that Google maintains.
Okay, so what is the difference in your view?
So I think the difference in our view is, first of all, to the extent that I heard opposing counsel, and this is in their brief, just suggest that Google's database is quite large. I don't think that in itself is a problem. I mean, obviously you could get a warrant to search a large house where the rooms are accessible to one another, or a large file room, even if it's physically separated across multiple rooms in a facility. I think the main difference here is that and you know, Your Honor, here I maybe am going to resist the physical analogy a little bit, but I don't think that these are the same thing as discrete storage lockers. These are more like storage lockers that don't have the set of expectations that I was just positing in answer to your hypothetical, and really are like a bunch of storage lockers with a glass wall. You could imagine, Your Honor, a coat check where we know that somebody dropped off drugs at the coat check, and we know what the person's name is. We don't know the coat check number. On their view, we couldn't get a warrant to go look at all the bags for the ID on the bag for the ID matching the person who dropped off the bag, because those would be unnatural bag searches that would be unlawful under the Fourth Amendment, and so we'd wind up searching everybody's bag. I think this is somewhat addressed, somewhat obliquely, I suppose, by the citation we have on page 44 of our brief to Chapter 8 of Professor Lefebvre's treatise, which allows for, even in a bailment situation, we don't think this is a bailment situation, but even a bailment situation, there's general agreement among courts that the bailee, the person with possession of the property, can look at it on behalf of law enforcement within the terms of the bailment. And here, what you have, again, we deny that it's a bailment, but if you want to analogize this to some kind of bailment scenario like you might have with the storage lockers, we'd still be within the terms of the bailment because Google wasn't doing anything other than stuff that Google could already do.
Thank you, Mr. Fagan.
CompuBear, the counter argument is that when you're out in public,
you always get a warrant, you said, and
where
the states
you are
always get a
is
warrant.
public
So,
information.
in terms of practical
I'm not saying it's correct. I'm just saying that's the counter
that
argument,
would
and that's the government's
ensue,
argument here.
I gather there would be no practical problems. I understand your legal theory, but no practical problems from our saying that a warrant is required. Is that accurate for these particular kinds of warrants?
Your Honor, if the court were to say that this warrant was fine, we have no...
That wasn't my question.
Well, I mean, Your Honor, I think it is a huge
The
caveat.
question was, are there any practical problems that you want to identify
with getting a warrant in particular?
Yes.
I don't...
And I assume the answer is no, because you've many times today said we always get a warrant in response.
That's right, Your Honor. My answer is no, but I would worry about an opinion that...
How we say that, I get that.
Well, what you say.
Yes.
But like, I don't think we've had practical problems getting the warrants we need in these cases.
And then
Kavanaugh
if a warrant's
sounded
required, it comes down to how particular, I think, correct? It has to be in describing.
I do think...
And on that, I just want to, I think you're going to agree with this, but I just want to get this out there and you tell me, there's a big difference between the issuing judge and the reviewing judge. That's the good faith. And the issuing judge, it seems to me, we should set some parameters, reasonable temporal scope, reasonable geographic scope, but then we trust issuing magistrates around the country to implement those rules. When it comes to the reviewing judge, we don't micromanage in second guessing what the issuing judge did so long as it doesn't exceed, certain bounds that we've set forth. Is that correct?
Yes.
And what should we say if we say reasonable temporal and geographic bounds for these kinds of geofence warrants? Is that all we need to say? Maybe you want us to say the ones in this case. Should we get into this case, or should we just say it has to be reasonable temporal and geographic bounds and send it back to Justice Alito's first question? We're at the reviewing stage, not the issuing stage here.
Your Honor, I think that would probably be the better course because I think what this court's centuries, frankly, of Fourth Amendment jurisprudence teach is that it's difficult to put a ton of meat on the bone of reasonableness in this context or probable cause or reasonable suspicion or any of these standards?
Yeah, and this is particular. How particular, is 150 meters okay, 200 okay? It strikes me micromanaging that's going to be problematic, and it's really problematic when you're distinguishing the issuing judge from the reviewing court down the road, given what we've said, reviewing courts have to be extraordinarily deferential.
Yeah, and I think the court could direct some attention to the magistrate about, not wanting, as I was suggesting to Justice Jackson, drawing parameters that under local conditions are likely to turn up much more than the government needs. But
Exactly. If we say things like that, we trust the issuing judges around the country who do this every day to make.
You should trust them, Your Honor, and frankly, our incentives are perfectly aligned with theirs, because when we're seeking a warrant like this, we don't want more information than we really need, because that just increases the noise-to-signal ratio and makes these more difficult to actually find the criminals. I believe there's some suggestion from opposing counsel that often these warrants get abandoned or quashed and they don't really turn up much evidence of crime, and that may be because some law enforcement agencies, I'm not impugning any specific one, we have many wonderful law enforcement partners, aren't drawing the parameters narrowly enough to even help themselves. So everyone's incentives are aligned here.
Thank you.
Justice Barrett?
So you described Mr. Unikowski's position as maximalist, but there's a risk of the government's position being maximalist the other way. And I think, two particular concerns are the ability to track into private residences, and you didn't concede that. The other is calendar, photos, email. Can did I understand you before to say that you are conceding that would be different and that would be a search?
Yes, and I do concede that tracking into a private residence without a warrant, I think, is a very, very difficult argument for us to make, and I'm frankly not sure that we would actually make it. I was simply noting that unlike in Caro, where the court held that we would have needed a warrant.
Sure, but you didn't rule it. You didn't rule it out. I understand your hedge.
I didn't want to categorically rule it out.
Right, but you are saying that you would need a warrant for calendar, photos, email.
Yes.
That would be a search.
Yes,
okay.
and let me. I'm happy to explain again why I think that would be.
I just wanted to make sure we had a crisp understanding of what the government's position was on that, so that's
yes,
sufficient.
that is the government's position on both of those issues.
Justice Jackson?
Yes, really quickly. I think there's something about the iterative process that may matter, and so just taking Justice Kagan's hypo really quickly for an understanding of what is happening. Tell me if the government is thinking about it in this way. You keep saying this is like storage lockers with glass fronts, with glass in the front of it. They don't have solid doors. Anyone can look and see what's in there. So step one is the government saying, tell us if by looking at these lockers, any have bags in them that might have a gun in them. Give us the list of the ones or how many have that, I think is a sort of a step one concern. And then maybe step two is once you've gotten that subset, open the lockers and see if there's really a bag or feel if there's really a bag. And then step three is open the bags inside each of the lockers. I feel like there's something happening with the way in which Google is providing this information in response to the government that may be requiring more probable cause or more particularity as you go along. So what is the government's thought about that?
Your Honor, with my continuing caveat that I think there's a limited utility in some of these physical analogies, I would kind of resist breaking it down exactly that way. I think step one, if we want to use the gun example, step one might be more, okay, you've got a glass partition here, tell us which of them have guns in them. Number two would be, okay, of that subset, continuing to look through the glass wall, you don't even need to open it for this because this is still stuff that is exposed to your view. Please tell us which of them have a gun and a box of ammunition. And then step three is, okay, for the 2 or 3 you found, please tell us who's rented those storage lockers.
Do you agree that you need more to get to each step? I mean, here, what criteria did the detectives use to narrow down the list from the 19 to the 9 to the 3 that were ultimately there? And wouldn't a particularized warrant need to have some criteria in it to guide law enforcement at each of these stages?
So, Your Honor, with apologies, I think I need to take a step back and say that I don't really view this as getting more particularized. I believe there was enough probable cause that the original warrant was and the 19 people that turned up, probable cause to believe those people would be either witnesses or suspects. And then there's a question of how to figure out which ones to follow up on. So what you actually have here is a warrant that I think is fully particularized with probable cause the whole way through.
You could have gotten the 19 names from the beginning.
I think that we could have, but in order to maximize privacy, what happened here was that the warrant included a minimization requirement on the government at each step, which is akin to the kind of minimization requirement you see in the Wiretap Act.
Okay, thank you.
Okay.
Thank you, counsel. Rebuttal, Mr. Unikowski?
All right, back to rebuttal. Hey, if anybody would like to keep me running,
Your Honor.
please
So I'd like to
consider.
say a few words about why this was a
hit my
search,
Venmo.
a few words about the warrant,
I
and
got
then
a lot
finally
to
why
hit
the court should decide
before
the
next
case.
week.
So first, why this was a search. I welcome counsel's concession from the podium that if there was a search for something like something else in the cloud, like email or calendar entries or photographs, in that case, there really would be a search and a warrant would be needed. But although I welcome that concession, I just don't understand the distinction that is drawn between those types of data and this type of data for Fourth Amendment purposes, either under a property or a privacy lens. So under a property lens, a person's relationship to their location information is the same thing as the relationship to their photographs or to their email. It's in their password-protected account. Counsel suggested that the answer might be different because it's in some way raw data. It's sort of generated by your phone as opposed to sort of a creative writing. So first of all, it's generated by the person in the sense that you move around. And second of all, I don't understand why that distinction has anything to do with the Fourth Amendment. Just as an example, your Fitbit or your Apple Watch might measure your heartbeat, and that information might be transmitted into the cloud. I still think that's yours, even though it's generated by your autonomic nervous system as opposed to the fact that you've written a journal. It just seems to me that if you have control over the data, you can turn it on, you can turn it off, you can delete it. It just doesn't matter if it's created by taking a photo as opposed to by the fact that you've decided to go somewhere. Similarly, from a privacy perspective, I don't see why a photo you take outside is somehow more private than where you were that day, because you don't have an expectation of privacy in like the thing that you were seeing if you were outside, but you do have an expectation of privacy in all of your photos, and likewise, you have an expectation of privacy in everywhere you've gone. So I think that if the court accepts the government's concession that you have an expectation of privacy or a property interest in photos and emails, the same thing would be the case for location history. Look, as to the warrant, on the step one issue, Justice Jackson suggested that what happened here is that the government received a list of like 19 different people that were in the geofence, but respectfully, I don't think that's what happened. What it actually got is all of the movements of those 19 people within that hour stretch. So it's a little bit like going into 19 apartments and taking a complete inventory of everything in the apartment, but not disclosing the person's name. Because if you look at the record, like all of those granular movements for that entire hour were exposed. And so that's why I think that the Ibarra case is directly on point here. You don't have probable cause to search based on someone's proximity to the crime. What happened here is each person's, what we regard as a virtual storage locker, was searched solely because of their proximity to the crime. And because their movements within the hour were exposed every 2 minutes, that's different from simply identifying which accounts were within the geofence. It's really exposure of information about them. And although it's nominally anonymous, the record shows it's actually quite easy a lot of the time to figure out exactly who a person is based on a relatively small record of their movements. But look, I've heard some questions from the bench today about steps 2 and 3. There's clearly a constitutional problem with those steps. I mean, as Justice Jackson suggested, the warrant wasn't particularized. There's no criteria given for identifying those people. In terms of how to decide this case, I think it would be a very significant case, giving a lot of guidance to the bar, if the court says, 1, a search happened, and number 2, at step 2 and step 3, at a minimum, there was a problem with the warrant without reaching some of the broader questions about general warrants or particularization if the court is inclined to resolve the warrant question narrowly, because the government has a lot of very striking arguments on the warrant issue that can have significant implications. One is that Google wasn't acting as the government's agent, so it makes a difference that Google pushed the button as opposed to the police. Another argument that's made is that the fact that software is conducting the search is constitutionally relevant, which could have revolutionary implications when like AI is monitoring everything we do as opposed to a human being. Also, the arguments that as long as something is nominally anonymous, that makes a Fourth Amendment difference, which also can have radical implications when de-anonymizing someone is very easy. So like all of these arguments that the government is using to defend the earlier searches could have very broad implications. So if the court believes that the warrant is unconstitutional at step 2 and step 3, it has the option of just setting aside those broader questions and deciding the warrant issue narrowly and also deciding that's a search. That would be more than a broad enough opinion to be useful to the bar. And I guess on the final question of whether the court should decide the question presented, look, it's very hard to see how the court could decide a question like this outside the context of a motion to suppress. If the court says the good faith exception applies here, it'll apply in every single case. I mean, Justice Alito posed the question, what about all the other people, the 500 million people who were searched? Well, number one, they're not told. All these warrants are sealed.
There we go.
The reason the outcry doesn't exist is that no one knows that thousands of times per year their accounts are being searched. Second, a 1983 claim by any of those people against the detectives would clearly fail on qualified immunity basis. So really the only way these issues will be litigated is through a motion to suppress in a case exactly like this one. And this is a good vehicle to decide the case because there's an extensive evidentiary record. There's declarations from Google, there's live testimony from Google. You'll never have a case with a more detailed account of the technical aspects of the case than this one. And so that's why I think the court should decide the Fourth Amendment question in this case.
Thank you, counsel. The case is submitted.
Hey, Mouse, I appreciate what you're saying, but today is probably not the day for it. We're on a different topic. Okay, so now we go to our next case, which is the Monsanto case. This is another big one. This is a big day, guys. I know it's a long day, but it's another big one. That was an excellent rebuttal. Whew. And once again, since I have a second, sorry to do this 2 times in a row, but if anybody would consider, please, I got a big thing to hit in the next 2 days. It's my birthday tomorrow. I would appreciate it. There's the Venmo. Thank you guys very much. I know we got Paul Clement coming up. Got other things in my bio if you want to hit them. And if you are particularly interested in that last case, I did a 20-minute video on it last night that I put over on the tubes because my video was too long. So like I had to cut it down from 8 pages to 2 pages. And what did they just say? So I actually recorded the 20-minute video just on Chatrie last night, which is all of the stuff about the Fourth Amendment and my concerns that fortunately did not come up about repression of the reasonable expectation of privacy that came up in Carpenter. And I was really, really concerned that they were going to, because I didn't know where Barrett was going to go in particular, what was going to happen. So, CompuVer, okay, all right. So this case is specifically about the labeling, but what's kind of interesting here, because remember when Chevron used to say that regulators who write, in the executive branch, who kind of write the specifics of how the laws are going to play out, have to be followed. And Chevron was overturned. Now judges can interpret.
24-1068, Monsanto Company
EPA
versus
says
Durnell.
this
Mr.
is
Clement?
a safe,
Mr. Chief Justice, and may
thing.
it please the court, respondent's label-based failure to warn claim is preempted twice over. First, it is preempted by the express terms of FIFRA's express preemption clause, which forecloses state labeling claims that are in addition to or different from those imposed under FIFRA. Here, a Missouri jury imposed a cancer warning requirement that the EPA does not require. That additional requirement is preempted. Now, respondent concedes, as he must, that the state tort law is a labeling requirement for purposes of the preemption clause. Bates held as much. Nonetheless, he insists that unless Congress expressly directs the agency to bind the judiciary, then the requirements that are imposed on a particular pesticide in the registration process and backed by criminal penalties are not federal requirements. That defies common sense, the statutory text, and this court's precedents. In particular, this court's 8-1 decision in Regal, where this court held that similar agency-imposed requirements on a particular device are federal requirements for preemption purposes. The same result follows from principles of impossibility preemption. The EPA regulation and the government's brief here makes crystal clear that a registrant cannot change the safety warnings on a pesticide label without approval of the agency. Thus, Missouri law here requires something that not only is not required by federal law, but that federal law doesn't even allow. Either way you come to it, either via express preemption or impossibility preemption, the result here is clear. Congress plainly wanted uniformity when it came to the safety warnings on a pesticide's label. Ignoring Congress's clear direction here would open the door for crippling liability and undermine the interest of farmers who depend on federally registered pesticides for their livelihood. I welcome the court's questions.
Mr. Clement, just for clarification, you seem to focus more on the label requirement in your brief and your argument, and respondent seems to focus more on the underlying statute, FIFRA. I could be wrong on that. Would you comment on that?
Well, I guess, Justice Thomas, I think about it as a level of generality debate. And I don't want to put words in my friend's mouth, but I think he says, well, you know, what's the conflict here? State law looks to whether it's misbranded. Federal law looks to it whether it's misbranded. And I think that actually mistakes the inquiry both on the state level and on the federal level. I mean, state law, at least the applicable state law here, really doesn't address labeling of pesticides. It's a negligence duty of good care or due care. The way that you get to actual pesticide labeling is a jury applies that general tort law to a specific device and then decides a particular warning is necessary. In the same way, on the federal level, you don't look just to misbranding in the abstract, but there's a process to take that down to the concrete. And that process at the federal level is the registration process, where the agency can't even register the pesticide unless it makes the determination that the label complies with the statute.
Well, I think my point is, first of all, this is a herbicide, not a pesticide. But I think my point is that what is the operative federal statute or regulation that has the preemptive effect? Is it the regulation, is it the labeling requirement, or is it FIFRA?
So it's all of the above, but to give you a textual answer, it's the federal requirements under FIFRA. And that word under, I mean, I know the other side sort of mocks us for focusing on a preposition, but the word under is important here, because if the statute just said, the preemption clause in particular, 136 VB, if that provision said by FIFRA, there might be something to my friend's arguments. But the language of FIFRA's preemption provision, just like the language of the preemption provision from the medical device amendments that were at issue in the Regal case, both of those uses the word under, and I think that word textually captures the various requirements that are imposed at a device-specific level or a herbicide-specific level in the context of the registration process here.
But Mr. Clement, you don't dispute that a product that has been registered can become misbranded, right?
Sure, and the clearest way for a registered pesticide or herbicide to become misbranded is to omit something from the label that is required by EPA in the registration process.
So you mean they just don't follow the process, but are you saying that if new information comes out in the 15-year interregnum between registration and re-registration that casts doubt on the efficacy or the safety of this product, you could have a product that is misbranded even though it has been registered and initially labeled properly, correct?
So I would take issue with that with respect to safety. Efficacy, as I think you know, is different,
Eddie,
and that's why I think the Bates case is quite distinguishable, because the agency actually doesn't have to evaluate efficacy. But as to safety, I think the process, if there's some new information that comes out. I mean, first of all, the registrant has a statutory requirement backed by criminal penalties to bring adverse information to the agency.
No, I understand how it is brought to the agency's attention under the statute. What I'm asking is, could we have a world in which a product that has been registered the label is consistent with what the agency has said is appropriate at the time of registration.
Mouse.
But let's say a new research study comes out at some point between when the EPA is statutorily required to look at it again, that casts doubt on the safety of this product. So my understanding is that under Bates and the way the statute reads in saying that registration is not a defense to the offense of misbranding, that you could have a product that is registered that becomes misbranded. That's my only, am I right about that?
So I disagree with that.
Okay.
I mean, the government may have a different view. I think the way that you deal with that and the way the agency deals with that is either through some amended registration or some cancellation process, which could be subject to judicial review. But what you don't just do is to say, well, like, there's been label drift here.
No. I'm just asking you whether it can
Braden.
be, whether misbranding and registration are two separate things.
They are two separate things, but I guess what I'm resisting is the idea that because of some subsequent development, a registrant who uses the EPA-approved label could somehow have just kind of drifted into a misbranding violation. I don't think that's the case.
Just to put a pin on that, I do want to just make sure I understand where you're coming from. So you're saying a properly registered product can never be misbranded?
I'd say, no, I wouldn't say that. What I would say is a registered product that is marketed as labeled and approved by the agency.
Right, can never be misbranded.
Is not misbranded.
Can never be misbranded.
Well, I mean, right, but of course, the easiest
I
way
just want to make sure I understood.
Yeah. I mean, that is my position, but I do want to say it's not that registration somehow makes misbranding impossible, because you can deviate from the agency-approved label.
That wasn't my
But could
question.
the
I'm sorry.
agency come after you for misbranding if you didn't comply with your statutory obligation to give the updated information to the EPA?
Absolutely. But it wouldn't be a misbranding action. It would be a criminal action or a civil action for violating your specific requirement under 136D, I think it is, to keep the agency updated. And I think that's important, of course, because that would be the federal government essentially making sure that its registrants are continuing with their ongoing obligations. And that would sort of be more consistent with the thrust of Buckman, where if you have a situation where your concern is that somehow the registrant hasn't done something they're supposed to do vis-a-vis the agency, you give the agency the ability to take care of that. You don't say somehow you're going to put that all in front of a jury, and the jury is going to determine not just how this should be branded, but also whether or not the registrant kept the agency sufficiently up to date.
But
What if,
go ahead.
what if the agency, EPA, says we've got this new information and we're reviewing it. As soon as we get to a point where we feel comfortable recommending something, we will. In that situation, the state can't make a determination that, well, we have this new information, so that it's perhaps the EPA's determination of the label shouldn't be given such determinative effect. In other words, it's not necessarily the case that they're doing something inconsistent with what EPA would do. It's simply a fact that they're responsive to the new information more quickly than the federal government is.
Well, if they're more responsive than the federal government, and the way they sort of manifest their responsiveness is to mandate an additional or different labeling requirement, I think that walks them in directly to the plain text of the express preemption in FIFRA. And I don't think the situation's any different for purposes of medical device amendments in this court's decision in Regal. You could have the same situation where there's additional information that comes to light, and there are processes for getting all of that in front of the agency. If the agency takes its time, and it might want to take its time because it's charged with the responsibility of looking not just at sort of how the new information affects hazards and the like, but also how it affects the alternative pesticides, how it affects the overall dynamic and the rest. I think you want to give the agency the time to do that. And I think in that respect, it's important that when, the real way to deal with it, I think, would be if you think the agency's not being responsive enough, is to initiate a cancellation proceeding.
Well, I mean, how is that consistent with 136A(f)(2)? It seems to me when you're saying, well, the state can't do anything about it, it's because you're relying on the registration.
That's where the
Well,
question
no, I
of
don't think so. I think you're relying on the
label
entire
comes from.
registration process. But I do think with respect to F2 in particular, I mean, first of all, I think the first problem with relying on F2 to be a game changer here is that F2 actually, as written, really, as I read it, is only limited to EPA enforcement actions. Because what it talks about is that the registration is in no event a defense for the commission of any offense under the subchapter. And that offense under the subchapter, I think, does talk about an EPA enforcement action. And I don't think even a non-preempted state tort suit is an offense under the subchapter. So with all respect, I think F2 is a bit of a red herring here. I do think, though, as long as we're looking at F1 is actually the more relevant provision here because that's the statutory provision that tells a registrant that they can't change the label without the agency's approval.
Before we leave F2, if, just supposing, that EPA can bring a claim against you for misbranding and seek criminal and civil penalties despite a properly registered item, how would it be inconsistent with FIFRA to allow state tort suits to do the same thing?
So it would still be inconsistent with FIFRA and the plain text of the statute to allow a state tort suit to do the same thing. And if you imagine a situation...
Yes, why is the question?
So why is because there would be a grave risk, and I think it is manifested in this case, that the state requirement would be different from or in addition
Assuming it's the same.
So even if you assume that it's the same, I think that you have a problem here, which is the idea would be that the state requirement would be to add something to the label. And under the plain text of F1 and the relevant regulations, 40 CFR 156.70 sub C and 152.44 sub A, those provisions say that the registrant cannot change the label with respect to state
That's really
norms.
what it boils down to then for you. It's not that you can in fact have misbranded but registered items, and EPA can seek remedies against you. You're just saying nobody else can do the same, even if it's the parallel proceeding, no additional requirements, because you have to go through processes to amend the label. So is it kind of this really boils down to the impossibility argument then, doesn't it?
Well, I mean, I think they're closely related. I think they're slightly different. I mean, part of it is like you've asked me to assume something. Which is that the EPA rather, would go after us for misbranding. I don't think the EPA would ever go after a registrant for a misbranding that was based on the failure to include something on the label that EPA itself says that they can't unilaterally add to the label. So I just so maybe EPA would go after a registrant in the context of some efficacy claim or something like that, where EPA's position is the registrant is perfectly free to change the label. But where the arguments sort of come together is because EPA quite clearly takes the position that as to the safety warnings and the hazard warnings, those are things that the registrant can't change on their own.
Well, with respect to that, if it all does boil down to the impossibility idea, that it's hard to add to these labels without EPA's permission, what do we do about the fact that, at least as briefs before us suggest, that registrants have added cancer warnings to their labels without EPA permission or objection?
Oh.
So I think those are, essentially just a couple of episodic things that the EPA itself addresses in their brief and says were essentially implementation mistakes. I mean, there may be slight quibbles about kind of each one of them and how they came to pass. One of them I don't think was actually construed by the agency as a hazard warning, so maybe they thought that's something, was more of a controversy warning about Prop 65 or something like that. And of course, in fairness, this is not a situation where the EPA has always had exactly the same interpretation across administrations.
I spot you that.
Yeah, no, exactly. But I do think, my short answer to your question is to the extent that was ever allowed, it's actually flatly inconsistent with the EPA's regulations that haven't changed across administrations. And I think those are worth looking at carefully because they are unambiguous. I mean, 40 CFR 144A and 156.70C, and that one is just absolutely unambiguous. You as a registrant cannot change your safety warning. Full stop.
If
I was wondering the
EPA
same thing,
came
Gustav, about
after
Prop 65.
for the label after telling you what must be on the label and saying you can't change the label legally. I mean, that would seem like a due process problem or something where the agency says you have to do this and then sues you for doing what they told you to do.
I completely agree, which is why I resist the idea that you could have a pure misbranding claim brought by the agency against a registrant for marketing the product with the EPA-approved label that EPA tells you can't change.
Even in a new evidence circumstance, I feel like I understand your argument with respect to the T1 registration. EPA's looking at the label. It makes a determination on existing evidence. But there's a 15-year window between when that product has to be re-registered again. And lots of things can happen in science in terms of developments about the product. So if the product can become misbranded because of new information, I guess I'm just wondering why you think that you couldn't have a situation where it would be perfectly rational for either the EPA or the states to bring to the attention of that manufacturer this new information and process a claim related to it.
All of that can happen, but it doesn't become misbranding. What happens is that information, first, the registrant has a statutory obligation backed by criminal penalties to bring it to the attention of the agency. And then second, anybody can initiate a cancellation provision and get judicial review under 136N, and the government has taken the position here that that's subject to judicial review.
Thank you, Counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
I just want to pin down the area of dispute because I, too, believed that misbranding and registration were not inconsistent. A claim by FERFA that someone has mid-branded can come even when registered. You're taking the position, I think, that misbranding would be limited to things that are not covered by the registration, meaning you change the label, you add something to it, you change it in some way, correct?
Correct.
You are, I think, answering Justice Jackson and Justice Kavanaugh, I think, by saying, if it's a failure to warn of something you should be warning, that would not be a misbranding claim. It would be a violation of a FRIFRA obligation to disclose that information and ask for a change.
Absolutely. And I think that way of looking at the world makes the whole regime, A, mirror the medical device amendments regime, but also makes it work a lot more sensibly, because otherwise what you're basically telling a registrant is they can go through this whole process, which exhaustively considers not just the product and its active ingredient, but all in conjunction with the label to make sure that it's safe and effective as used and has like a danger label if it needs it or a caution label it needs it. They go through all that process, and then the next day they market it as labeled, and they could have that all be subject to a misbranding claim.
I think the problem is 136AF2 because it also says a valid registration, however, is prima facie evidence that the pesticides, its labeling and packaging comply with the registration provisions of FRIFRA, but it's prima facie, it's not presumptive. And so it seems to me if it's prima facie, it could be rebutted that FRIFRA could come in and say you misbranded because you failed to tell us about this risk.
So misbranding isn't the only offense under the statute, and there's a specific criminal penalty for failing to comply with your obligations as a registrant under that. So if you have a hypothetical registrant who has some terrible information that comes out that they're obligated under the statute to give to the agency, and they withhold it, they are certainly subject to criminal penalties, but it's not a misbranding claim. And I think it's a mistake to think all the different ways that a registrant can violate FIFRA all come down to misbranding. I mean, misbranding is just one species. And of course, the most obvious violation, and this is why there isn't this inconsistency between registration and misbranding, the most obvious way to commit a misbranding violation is to omit something from the label that you were told you had to put on it in the registration process. That's a misbranding claim. And of course, it would only be prima facie evidence because you blew it, you misbranded.
We have two lines of impossibility defense. Pliva and Wyatt are also there. Doesn't the history we're showed about the manufacturer who added the California 50 proposition information without FDA approval, doesn't that defeat your impossibility argument? Doesn't defeat your other arguments, but why doesn't it?
Because I mean, sorry.
The agency has, you've said, by error, whether it's error or not, they've permitted this to be done.
So I don't think, my answer to that would be, I don't think Pliva and Bartlett come out differently if you could point to a couple of generic manufacturers who ultra-virus, and in a way that they actually weren't allowed to, tried to change the label on their generic pharmaceutical. I think that would have actually made those generic pharmaceuticals mislabeled, if I understand that regime, which is why it didn't happen. But I think you look to the law. You don't look to whether somebody essentially did something that was ultra-virus. And if you look to the law here, this is, and the government flat out says this in their brief, this is really analogous to the generic labeling regime, not the branded regime.
Thank you.
Justice Kagan?
And Mr. Clement, not to say you're wrong about your view of the scope of the misbranding actions, but if you were wrong, how would it matter? Could you still win if misbranding actions were more expansive than what you're arguing?
I mean, I suppose I could, and I suppose like you could, kind of just go with impossibility preemption and make this like very simple, because I just think you look at those regulations and it makes it clear we can't change the label. The reason I'm sort of fighting on this, and the reason I think I'm not wrong, is because I think that there, as I said, when it comes to misbranding, that's very specific. The easiest way to commit a misbranding offense is to omit something that you're required in the registration process to put on the label. If you omit something, and if, of course, the state thinks you need to add something that EPA is not requiring you to put on the label, I mean, that just walks squarely into the text of the express preemption clause. And part of the reason I'm kind of like resistant to put all the weight on impossibility preemption is because, in some respects, the express preemption clause is even broader because it doesn't require an actual conflict. If the state imposes a labeling requirement that's different from or in addition to, that's still preempted by the plain text of the statute without really regard to whether it's misbranded. And it seems to me that if EPA, once you go through the registration process, they tell you what's required to be on your label. And there's really no way to look at this case and not come to the conclusion that a Missouri jury has told us that a cancer warning that EPA hasn't required us to put on the label is required to put on that label. And that just seems like a requirement in addition to what's required by the EPA. And if you can get there without saying the word misbranding or thinking that, I have to be right about that, I'm totally fine with that. I just happen to think that from the perspective of my client, I guess what I would say is this. We go through that entire registration process. The way I would understand that is the agency is giving us a green light that we can then go forward and market a pesticide or a herbicide as labeled and not have to worry about a misbranding offense. We got to respond to all the other statutory requirements. And again, that's exactly parallel to what happens in the medical devices amendments case. Once you get that device and it's approved with labeling, you can't deviate from that labeling. And if there's additional science that comes along, you got to get the agency apprised of that. But you can't be held liable in state court for marketing a medical device that's labeled exactly like the FDA told you to label it. And I think the same thing should apply under this statute.
Justice
Anybody else? I keep hearing Grandpa Simpson. I'll be dead in my grave before I recognize Missouri.
There are ways, I think you're saying, that EPA can change requirements going forward, but if it tries to say you were misbranding when you did what they told you to do, that's a retroactivity problem of sorts in the sense that they're penalizing you retroactively for something they're saying is now required that they didn't say was required before, in fact, was prohibited before.
Yes, and I actually think the retroactivity frame is a helpful one, because if you look at this statutory scheme, the real way you sort of change warnings or take a pesticide off the market is through the cancellation proceedings. And when the agency actually goes through the cancellation proceedings, there are requirements. They're supposed to allow the manufacturer, except in extraordinary cases, to continue to sell the existing stock. They're supposed to make a specific analysis that takes into account the reliance interest of farmers and other users. And all of that kind of makes sense, that if you're going to like sort of prospectively take something off the market, you go through an orderly process. And one of the anomalies of allowing a state tort remedy to be essentially a requirement is it does have this kind of retroactive effect to it. And I think that's what makes it particularly problematic here.
And I think you just covered this in part, but to Justice Jackson's good point about new science, you're saying the way you account for new science is on a process that changes the requirements going forward, not on a process that retroactively tells you that what you did yesterday as ordered by EPA is somehow illegal.
Absolutely, and it's an agency process that takes into account
Unless
all
you
of
had
the various
evidence,
factors,
unless you
costs
knew.
and benefits. And of course, the agency has incredible resources at its command, including peer-reviewed panels, cancer review, and the like. And this case provides a perfect example of that. It's not like
This
when
is the
this
tobacco
IARC study came out and said that, you know, glyphosate, like hot beverages, is a cancer risk. It's not like the agency said, we don't want to hear about it. They exhaustively studied it, and they actually did peer review that IARC doesn't do. They looked at more sources than IARC did, and then they came to a conclusion that's shared by regulators around the globe that glyphosate doesn't have a cancer risk. It's not carcinogenic.
Thank you.
Justice
I
Barrett?
don't know if anybody saw the other day,
design
but
defect
Kennedy was
claims
just asked
preempted?
about this because this
They're
was what he
only
ran on, was
preempted
getting
if
rid
they
of
are
this.
disguised failure to warn claims. But that is an important difference from this context and the medical device amendments context, which is, although they're worded similarly, the preemption clause in the medical device amendment sweeps in design defect claims, and here it's really just on the labeling. But you know, the only reason I do hesitate is because it's obviously tempting in a world where you can bring design defect claims but not failure to warn claims that you try to make a design defect. Well, the design problem here is the way you designed your label or that you failed to warn. So with that caveat, design defect claims are not preempted.
Okay. And then, you know, you put most of your weight on express preemption, but obviously you do make the impossibility argument as well. How do you think about implied preemption when there is an express preemption clause present? It seems odd to move on to implied preemption. Wouldn't it all be governed just by the express preemption clause?
Well, this court has been very clear, and this is critical, that you don't sort of say, well, there's an express preemption clause, and so that's the only preemption we're going to do here. We're not going to do any kind of implied preemption analysis or impossibility analysis. You've squarely rejected that, and I think you should do it here too. I don't think there's a huge difference between the two here. I think if you sort of think about this, like Regal was an express preemption case and just an express preemption case. But of course, when Justice Scalia decided Regal, he didn't have the benefit of Pliva and Bartlett, which come later. And so if he did, you know, he might have said in Regal, well, this is both an express preemption case and an impossibility case. So I think both roads sort of lead there. At the end of the day, though, you know, I kind of like text. And I do think we get there on the express preemption provision, and I do think that, you know, in some hypothetical case, maybe not under this particular reg or this particular provision, but it's going to matter that the words "in addition to" are there, because that is, at least in theory, it doesn't actually require a conflict at all for a state requirement to be preempted. As long as it's an additional requirement, that's textually enough for it to be preempted.
Well, yeah, I mean, it seems to me that your impossibility argument is kind of wrapped up into the express preemption argument, because the whole reason it's impossible is that you are required to do that. You can't change it, and the state is prohibited from requiring anything in addition to or less than.
Yeah, I guess here's the difference, though. Like, even if in theory we could change the label, I mean, we're still not required to in the registration process, and I still think the way I understand this is like, look, there's a broad general standard of misbranding. EPA looked at that and made it concrete in terms of this particular herbicide by saying, here's what you need on your label. A Missouri jury did the same process, took a broad standard, made it concrete to the same herbicide, and said, you need a cancer warning. And so under Missouri law, a cancer warning is required. Under federal law, a cancer warning is not required. That is a requirement that is in addition to the federal requirement, and that would be true even if we could change the label. So here, they end up kind of being coextensive, but I can imagine a world where they're not. In some respects, if you're concerned about the one or two outlying examples where somebody was allowed to do a warning, I mean, the express preemption clause may be a little bit more impervious to that objection. But again, as I say, we're happy to win either way, but it's hard not to like the text.
Thanks.
Justice Jackson?
So I guess I'm not sure that retroactivity in the questions that you explored with Justice Kavanaugh necessarily captures all that's going on here. And I worry a little bit about the way in which you are describing this and its seeming inconsistency with what we said in Bates. So I think that one way to understand this scheme, the statute scheme, is that there's a registration requirement and there's a no misbranding requirement. And every 15 years, EPA makes a registration decision that sets the requirements for a pesticide's label based on the information that EPA has considered at that time. But in the years between registrations, the company still has to comply with the no misbranding requirement. And I guess I'm trying to understand why it couldn't be that both the EPA and state tort law can enforce the misbranding requirement in the interregnum. So, I mean, I think in Bates we said that FIFRA contemplates that pesticide labels will evolve over time. And we said, quote, tort suits can serve as a catalyst in this process. And you can see how that happens, right? When new information comes in that 15 years, the threat of tort liability is one thing that spurs the manufacturer to go to the EPA and make sure that they're giving them the information. But it also enforces the no misbranding requirement. So why isn't the kind of concept of the way the scheme works, as we laid it out in Bates, how we should be thinking about it? It's prospective, not retrospective in that sense.
So let me try to use Bates as an example in answering your question. So the one thing I think Bates was clearest about is, kind of the clearest example anyways, that Bates contemplated of a conflict that would trigger the express preemption provision is federal law says for this particular pesticide, all you need is a caution label. And state law comes in and says, no, for that pesticide, you need a danger label. Bates says that's a clear conflict. Well, how does EPA decide that a particular pesticide needs just a caution label and not the more serious danger level? They do that in the registration process by examining the toxicity of the substance. And then they say, all right, this is sufficiently non-toxic that it just requires a caution label. Now, let's say 5 years goes on and somebody with some new science goes in before a state court jury and says, actually, EPA got it wrong. This thing is more toxic than they thought. And so under Missouri law, you need a danger label. I think that would still be clearly preempted by Bates, and the fact that you could tell the jury you need the danger label in order for the product to be not misbranded would not change anything.
No, I understand, but isn't there a world in which that is a different circumstance because the EPA has not yet considered that information? So you're not actually conflicting with, you're not doing anything different or in addition to the determination that the EPA had made based on the information that was before it. I guess I see that, I mean, it's nuanced for sure. I mean, the way you're saying it is pretty straightforward, but you're reading the express preemption statute as though it says such state shall not impose or continue in effect any requirements for labeling or packaging, period. And this says in addition to or different, which suggests that there could be a parallel state enforcement proceeding happening.
Well, I guess I would answer by saying only a completely parallel regime. So if they want to say that, you know, if my client omits something that EPA has said must be on the label, and somebody gets hurt because that warning's not on the label, then you can have a tort claim that's a failure to warn claim that basically is a negligence per se claim at that level of generality that says you're liable because you didn't follow the federal requirement, and we are going to give you a state remedy. That's why it is in addition to or different from. It's not, we're not striking those words from the statute. And the one thing I would say is if you read Bates carefully, at the end of the opinion on this point about tort suits can get information, there's a block quote from a Court of Appeals opinion. And if you actually read it carefully, what the court says by quoting that is these tort suits could generate information, and then people could go and ask EPA to allow the registrant to change the label. So even in Bates, there's a recognition that there is not this unilateral ability to change the label, at least with respect to safety and warnings. And I would say this is where my answer that you can still have design defect claims is important, because that could be part of the process where additional information is generated and ultimately brought to the attention of the agency. This is a narrow but critically important preemption clause. It focuses on label-based failure to warn claims, and that's exactly what this is and should be preempted.
Thank you.
Gustav said if the company knows that the EPA is using bad information, then do they have a duty to correct? It's a good question.
Ms. Harris?
All right.
Mr. Chief Justice, and may it please the court. Many paths lead to preemption here. The simplest is that state and federal law impose different and indeed conflicting labeling requirements for Roundup.
Everybody hit
Missouri forces petitioner to add cancer warnings or face tort liability. But federal law requires petitioner to stick with the label EPA approved in registering the product unless EPA approves a change. EPA registers pesticides only if EPA approves their labels as adequate to protect health. Federal law then requires manufacturers to keep using that label. Manufacturers must apply to amend registration to change the label. Indeed, regulations provide specific statements pertaining to the hazards of the product must be approved by the agency. That's 40 CFR 156.70. Missouri thus requires adding cancer warnings, but federal law requires EPA to approve new warnings and tasks EPA with deciding what label changes would mitigate any health risks. State law must give way. I welcome the court's questions.
Ms. Harris, I asked you the same question as I asked Mr. Clement. It seems as though you are focusing on different things from the respondent.
We disagree with, it's true we're focusing on different things. I would say we are focusing on the text, and both the text of the statute and the regulations, specific to how the misbranding mandate is implemented. So the text from which we are getting the do not change the label requirement, which I agree with some of the questions is central to the case, starts off with 136AF1 of FIFRA, which says if you want to change your label, go amend it. You have to get EPA's approval. EPA has to confirm it's not misbranded. And then for other federal requirements in Bates's framing, I would turn you to the regulations, which are not specific just to registration. They talk about how do you change your label. And so 156.70 is the clearest. It says for hazards like cancer, you have to ask for EPA's approval. And then there's a whole welter of other ones that reinforce that. And that makes sense because EPA deals with misbranding, both to prevent misbranding in what it actually has before it, and to protect against people who might be, if state requirements that might be adding things that are misbranded, by saying, no, it's all channeled to EPA. EPA has to review changes to make sure they don't confuse people. You really have to stick with your label to safely use the product.
So do you agree with everything that Mr. Clement said about how this regulatory scheme operates? And even putting aside the preemption question, is everything he said your understanding of how the agency works?
I agree with him. I would just add two refinements. One, he is correct that EPA doesn't go after people for, in a hypothetical world, if things change, would you have been in trouble for not changing your label even though EPA doesn't let you? That's right, we don't bring that kind of enforcement action. But two, not only was Mr. Clement correct in talking about cancellation proceedings, if new evidence does come to EPA's attention, and again, we don't think this is a new information case because of the time periods involved, even if it were, what EPA normally does, let's say it came to EPA's attention, we think this product might cause cancer. The requirements for dealing with that under federal law are completely different from a state just saying slap a cancer warning on the product. What EPA does, and this is at 136 AD1 of the statute, and then a whole bunch of regulations at 152.170 of the regulations, EPA first says, what's the exposure risk for cancer? Then EPA next asks, are there different forms of labeling that you could use for protective gear that would mitigate the exposure? And then if that doesn't work, EPA says, are there different things we can do to the label to restrict the use to particular crops, or say that only professional applicators can use the product? All of that, again, very different from the way that state law is processing it. And at the end of all of that, if EPA thinks that there needs to be a change in the label because it wasn't initially adequate to protect against that exposure risk, whether it's cancer, whether it's something else, but it can be solved for with these restrictions, what EPA does is not go after the manufacturer and say, you're in big trouble now. EPA has a default 120-day grace period to change the label. Now, if there's an emergency, EPA can shorten that significantly, their suspension powers. But EPA, this is at 152.167 of the regulations, has the flexibility to say when your label changes. So in all of those particulars, not only is this a situation where EPA is controlling how to respond to a risk or new information that might change the calculus about what happens, EPA is doing so in a completely different way than just saying slap on a cancer warning and assume that that will sort of solve for the issue, because EPA is looking holistically, not only at someone who might read the label and be exposed, but also at other people in the process and endangered species.
Well, and throughout that long process, in response to information that suggests there is a risk that's not on the label, the states cannot do anything?
The states can do things that add additional penalties, as Mr. Clement said, but what they can't do is try to sort of second guess or undermine this process. And I think that makes a lot of sense. Again, EPA is getting in new information. EPA is the one with suspension power. If you had 50 different states that are just like jumping the gun, Iowa says maybe this causes cancer. California says absolutely causes cancer. Some other state says this doesn't cause cancer at all, so put that on your label too. It completely undermines the uniformity of the labeling scheme.
Well, it does undermine the uniformity. I appreciate that. On the other hand, if it turns out that they were right, it might have been good if they had an opportunity to do something to call this danger to the attention of the people while the federal government was going through its process.
But what they have the power to do is to bring suits to, you can petition for cancellation or find many other mechanisms of saying EPA currently has it wrong, spur EPA to action. What FIFRA does not allow is throwing preemption out the window, throwing the express preemption clause out the window and saying states are perfectly fine to have a free-for-all, because again, FIFRA is designed to guard against both sides of the risk.
So the only thing that you need to worry about is the labeling, but the states can do anything else with respect to the particular cancer that they would like.
If I'm understanding the question correctly, states with respect to labeling cannot propose their own labeling. States, of course, remain free to restrict the use of the pesticides under 136 VA. So if a state said, look, within my borders, I just don't think this pesticide's safe, don't use it, they're free to do that. What you can't do is—
Why can't they impose tort liability then? If they can stop the product from being sold at all?
Because—
If that greater power exists, why doesn't the lesser power, without saying the label, we know we can't change the label?
Well, again, you could say you can't sell the product. What you can't do is countermand the judgment Congress put in—
About the label. You can label, you can put whatever label you want on it.
Then is the premise of it just a design defect claim? I'm sorry not to follow the question, but what states can do is say—
If we say it's so hazardous, we can ban it. Why can't we say it's so hazardous that there can be tort recoveries for it?
I think that would just be a sort of defective design suit, and it would go into what Mr. Clement said. Those are fine under Bates as long as it's not a label claim.
So those would be fine.
A design defect claim that is not masquerading as a failure to warn claim is permissible under Bates for the reasons Mr. Clement said and the reasons that Bates itself recognizes.
How does that petition for cancellation process work that you described to the Chief Justice? Can you lay that out?
Sure. People can bring petitions.
People, including states.
Sorry, people, I believe including states, there have been many brought by environmental groups, any other interested group. You petition to EPA to cancel. It's a way to test, is EPA—
Cancel the registration.
Cancel the registration. It then gets litigated out. There's judicial review of this process specified both in the specific cancellation provisions and more broadly in 136N of FIFRA.
Does that encompass a petition to change the label?
It could, in theory, be because you think that to cancel it, you could say it shouldn't have been registered at all because
Thanks,
it's
Bobby.
misbranded for whatever reason. Again, if EPA also thought that there was some sort of misbranding risk, like as a practical matter, what happens is EPA gets information and might ask the manufacturer, like, can you please change it, can you please try to amend your registration and change it? And if they don't, at that point, you might have misbranding.
Is there any judicial review of a denied petition?
Of denied petition for cancellation? Yes, the whole process is set off in 136N. It's
seem
the
odd.
petition process similar to denials of registration. The whole, any final EPA action under 136N is judicially reviewable. It's a very prescribed process. And on top of that, I just want to correct some sort of any misimpression. The EPA is just sort of sitting on its hands, like every 15 years it springs into action. EPA itself does monitor new information. Whenever it comes to light, it often calls for information from manufacturers. Dacthal is a great example of that. That is a pesticide where EPA became aware of possible thyroid risks in unborn babies. EPA asked the manufacturer for information. The manufacturer was dragging its feet. EPA threatened to suspend the registration. The manufacturer supplied the data. EPA wasn't satisfied and said it was going to cancel the pesticide. It's now off the market. So I don't think this is a situation
Really would
where
like to hear them bring up
there
tobacco.
aren't sort of means by which people can bring information to EPA's attention. The whole point of the registration process and why it takes long is throughout like that process, EPA is often soliciting information from people to comment on interim steps in the decision, and so that's one reason it takes a while, honestly.
Thank you, Counsel.
Yeah, good
Justice
stuff.
Thomas, anything? Justice Alito? Justice Sotomayor?
If I understood Mr. Clement, he was saying that even if the law permitted the manufacturer to choose to add a cancer warning, it would still be express preemption because the state would require it as opposed to giving the manufacturer a choice. Is that your position as well?
I would just put a little refinement on that. I think that's probably correct as a conceptual matter, but one reason backstopping it is the process I described, where if EPA identifies a risk, it has a completely different process and sort of mitigation procedure for figuring out what kinds of warnings are adequate to guard against the risk. So EPA is very zealously saying not only yes or no, do you need a particular type of warning, but for that type of risk, what is the best way of making sure that not just the person using the product, but people who might have secondary exposure to it or endangered species get the information they need to ideally mitigate the exposure risk.
So what do we make
Federal
from their
law still preempts.
2022 statement where they were approving the California Proposition 65 label? Hasn't been withdrawn, correct?
Respectfully, that's from 2012, and that is a different.
I'm sorry, I misspoke on the.
It's okay. It's with respect to a different product. So I think you make absolutely nothing of it. We have said repeatedly ever since then that was an error. More relevant are two things: one law, one facts. On the law, Mr. Clement is correct that the label regulations could not be clearer. If you are doing something like a hazard warning, which I don't see any way of describing a cancer warning as anything other than that, you must get agency approval. That's what it says. That's 156.70. Two, on the facts, I would say the even more relevant facts for Prop 65 would have to do with glyphosate itself. Whenever pre-first Trump administration, people were using those warnings on glyphosate products, they were always submitting amended registration requests. The agency approved those. So even that universe of Prop 65 warnings, which again are just saying California thinks this might cause cancer, not this causes cancer, even those went through the amended registration process requiring EPA approval. Now, the first Trump administration said, that's misbranding, don't do that at all. And there's a lot of water under the bridge at this point because those specific warnings were invalidated on First Amendment grounds by the Ninth Circuit. But I don't think Prop 65 can possibly get responded anywhere, either on law or facts for those reasons.
Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh? Justice Barrett? Justice Jackson?
I just quickly ask you about, doesn't the statute contemplate that the EPA will approve label changes if they're consistent with FIFRA? So we're not talking about an arduous process here.
Apparently
If
not.
the manufacturer proposes a label change, I think
not
the
allowed.
language of the statute says the registration shall be amended to reflect such a change.
But respectfully, it is very arduous because as part of that process, and if you look at the regulations at 156, it's the regulations at 156 onwards, what they say is you have to also submit data adequate to support the change so that the agency can go through and make sure whatever label change you're proposing, especially if it's a cancer or other hazard warning, is not itself misbranding, is consistent with RFRA. This is not just a send me a quick letter, don't tell me why you want to change your label situation. Again, and that reflects, these are regulations that are trying to implement the mandate not to have misbranded pesticides.
No, I understand, but it's the suggestion that, we can't do it on our own. It looks as though you pretty much can if you send the relevant information. The registration shall be amended.
Respectfully, I don't think the idea that just because you might think approval is easy in certain situations is enough. I think that would be directly contrary to Pliva and Bartlett, where the court said—
What about Wyeth? Isn't this like Wyeth?
No, it's completely different from Wyeth. There's a very stark contrast. For the changes to be affected regulations for the FDA for brand manufacturers in Wyeth, it really was, you brand manufacturer allowed unilaterally to change your label for this period of time. FDA will then tell you if it disagrees. Here, it's the opposite. It is, do not change your label. Under no circumstances, change your label if it's a hazard warning, unless EPA says yes. And that is in the heartland of what Pliva and Bartlett said, which is, if your action depends on the approval of a federal agency in order to do it, then you are not able to unilaterally act for purposes of federal law. And when state law is telling you you better change that warning, that is a direct conflict, or in the words of Bates, relevant here, that would be different from state law.
Thank you.
Thank you, counsel.
All right.
Mr. Keller?
Now.
Mr. Chief Justice, and may it please the court. You unanimously held in Bates that a pesticide can be registered and nevertheless misbranded, even if it uses the label that EPA approved at registration. Yet Monsanto now asks you for the opposite holding, that Roundup cannot be misbranded as a matter of law because EPA found for the first time 50 years ago as a matter of fact that it is safe based on information Monsanto submitted. After 2 briefs and a lot of podium time, Monsanto still hasn't pointed to one word in FIFRA's text that says the agency's factual findings at registration create a requirement for labeling. That's because the text repudiates that proposition in no uncertain terms. 136AF2 is an anti-delegation clause. It says that the agency's findings at registration are nothing more than prima facie evidence of compliance with the labeling requirements. Prima facie evidence is not a law of the United States made in pursuance of the Constitution. It is a thumb on the evidentiary scales that can be rebutted, and a reasonable jury has rejected that evidence. With no satisfactory response to 136AF2, Monsanto changes the subject, making the totally uncontested point that the express preemption clause talks about requirements under FIFRA. We agree, we're good textualists, we don't ignore prepositions, and we agree there are affirmative delegations of authority to the administrator to issue regulations that create labeling requirements. Monsanto's problem is they're not relying on any of those regulations. They're relying on registration and registration alone. There is nothing in, by, under, or next to FIFRA that makes the registration decisions that EPA makes binding labeling requirements with preemptive force. I welcome your questions.
Could you tease out your delegation argument and how that has, the impact that has on preemption?
Yes, I can, Justice Thomas. I think a good example would be, imagine if the EPA had promulgated a notice and comment rule. It went through an entirely formal process that in the Chevron regime would have unquestionably satisfied Meade, saying Roundup is perfectly safe. There's nothing wrong with glyphosate. If you put any type of warning on glyphosate, we, the EPA, determined that that would be misbranded. In the old regime, I think you could say we're going to engage the fiction that Congress intended to delegate that power to EPA. We don't need some source of text saying that they can do that. I think in the new Loper-Bright regime, you would say, point to text delegating that power to the agency directly. Well, they don't have that notice and comment rule, but they're trying to rely just on 136A, the registration process, to say whenever the EPA approves the label at registration, even if it's from 1974, that is the label. The label is the law. It can't be anything other than that for purposes of misbranding. But nothing in 136A says that. Everything that the administrator does under 136A is textually linked to the administrator's power to register the pesticide. He shall register the pesticide or he shall not register the pesticide. He's not liquidating the meaning of whether Roundup is misbranded for all purposes. He's expressing his opinion on the matter. You heard last week the FCC case, and it sounds like some of you might be willing to say when the FCC issues an order saying pay hundreds of millions of dollars, that's just the FCC's opinion on the matter. It doesn't become actually the law until a jury finds the facts and enters a verdict.
Oh.
I think there are other problems with 136 AF1. You heard my friend on the other side and my friend from the United States saying that that requires pre-clearance for a label. I don't agree with that proposition. Look at the text. It says if the labeling is changed, past tense, then the administrator shall amend the registration. There's nothing that requires the manufacturer to wait for the amended registration. There's nothing that even requires the manufacturer, if the EPA says, no, I'm not amending the registration, to walk back the label change. The only thing that the EPA administrator could do in that sense is bring a civil penalties action, a criminal penalties action where there would be a jury trial, right? Or bring cancellation proceedings where the manufacturer would get to defend itself in a formal adjudicatory process with cross-examination and calling live witnesses, the kinds of formality, again, even in the old regime, that would have been required before you give agency action the force of law. You said in Menson you're not going to play a mousetrap game to create impossibility. You're not going to benefit plaintiffs by saying, well, you could have gone to the FDA and sought pre-permission or approval, and they might have said yes. You shouldn't play a mousetrap game for the other side either. They shouldn't be allowed to say, well, we didn't even try to amend our label, which we unilaterally could have done. But if we had, the EPA might have told us no, and they might have brought these cancellation proceedings, and they might have then won those proceedings, and it would have stuck in court. That's too many links in a causal chain for impossibility analysis to apply. I also think we could talk about the regulations that my friend on the other side.
Go.
Do that.
There
Can you just speak to AF2 and the clause that talks about not being a defense?
Yes.
Mr. Clement indicates that that's not a defense to an EPA action. Is that your understanding as well?
No, I very respectfully think Mr. Clement has a pretty tortured reading of the first sentence of 136 AF2. It says, in no event shall this be a defense to any violation of FIFRA. Obviously, that includes any of the definitions of misbranding. You can see the offense in 136JA1E, which defines any misbranded sale as a violation of the statute. He wants to reread 136JA1E to say any misbranded pesticide is really just a pesticide that doesn't use the label that EPA approved at registration. That is not a possible reading of any misbranded pesticide, particularly given paragraphs B and C. So if you want to follow the statute, it's at page 40 of the red brief appendix. Congress knew how to lock in place information from the registration statement. Paragraph B says you can't sell even a registered pesticide with claims made for it, different than the registration statement. Paragraph C says you can't sell a registered pesticide with a composition different from the registration statement. If paragraph E were really meant to just be you can't sell a misbranded pesticide and the definition is the label departs from the one in the registration statement, of course Congress would have used a parallel formulation, but it didn't. So I think 136 AF2's first sentence can't possibly bear the meaning that he's suggesting. He also suggests, I believe, that 136 AF2's first sentence is not in itself the thing that he's using as the defense. He says it's not registration alone, it's registration plus the EPA's findings of safety at registration. That doesn't make any analytical sense. He's saying that the EPA has to consider safety at registration. So he's saying it's no defense by itself, it's just a defense if the EPA does the job that he says they are statutorily required to do, and then it's a complete defense. That's adding a lot of words to the statute that I don't think bear the plain meaning.
Your friends on the other side rely heavily on Regal, and they did in their opening briefs. And in the reply brief, they say, well, you just mentioned it, pages 49 and 50 of your brief kind of in passing. I wonder if you want to give a fuller exposition about why your case is different than Regal?
Of course, Mr. Chief Justice. I thought our 3 paragraphs at the end of the brief were persuasive, but let me hum a few more bars on that score. So first, there's nothing like 136 AF2 in the medical device amendment, so that's a huge distinction. 136 AF2, again, I think is making very clear that registration doesn't have the effect that the medical device amendments do. Second, in Regal, you found as a matter of the statute Not as a matter of regulation, we didn't have to ask a Loper-Bright question, as a matter of the statute, that once the FDA approved the medical device, you couldn't depart from the label. So that's an obvious distinction. And then finally, even then, you preserved the option of a parallel claim. In the penultimate paragraph of the opinion, you said, we're not going to address whether a misbranding claim could proceed here because there is an obligation under the Federal Food, Drug, and Cosmetic Act to not sell a misbranded device. Stop selling is the duty. Ms. Riegel might have been able to pursue that sort of claim, but she raised it too late. We're a court of review, not first view, as you said many times, so you're not going to address it. So you left open the question that's not open in FIFRA because you have Bates, and Riegel didn't overrule Bates sub silentio.
I mean, just to be simple-minded about this, Mr. Keller, you have
they're
a
kinda worn
preemption
down.
provision that's labeled uniformity, that's clearly designed to achieve uniformity in labeling. And what uniformity would your regime achieve?
Uniformity in law. So I believe that the express preemption clauses require uniformity in law. The
All right.
law of Missouri and the law of the United States have to be the same. They can't be in addition to or different from each other. So it is truly requiring parallel law. It does not require fact finders to find the facts the same way. So the law of the United States and the law of Missouri could be the same. One jury could say, Monsanto didn't do it. There's nothing wrong with this pesticide. Glyphosate is totally safe. There's no breach of duty. That's not a preemption question. That's a question of breach of duty. And a different jury could come out the way Mr. Durnell's jury did. Congress could, of course, write a different express preemption clause. Monsanto is lobbying literally right now for Congress to do that. And if they are successful through the bicameralism and presentment process, we would begrudgingly concede that these state claims would be preempted. But that's not the law Congress wrote.
You think it's uniformity when each state can require different things?
I don't think each state can require different things. The law has to be uniform. So if Missouri law was in addition to or different from.
The label's illegal in one state and legal in another state. That's uniformity?
I don't agree with that. The label's not illegal in one state and legal.
I don't know if I would have
in a
leaned
different
into that
state.
argument.
A jury has found the facts to say.
The label subjects you to liability in one state and does not subject you to liability in the other state. Is that uniformity?
Nobody's going to talk about tobacco. I am amazed that nobody's talking about tobacco.
That despite the government's claim of a cacophony or a patchwork or a crazy quilt, that's just the consequence of our civil jury system, where you have individual cases or controversies.
I agree with you, absent a
it just seems like
clause
the
that says
obvious answer,
uniformity in
right?
federal law.
Well, it says uniformity, but uniformity is the caption. What does the actual text of the uniformity clause say? It says you can't have any requirements for labeling in addition to or different from those required under FIFRA, and the requirements for labeling are those supplied by the misbranding prohibitions defined by Congress in 136 subsection Q. So as long as Missouri mirrors those requirements, Bates says a requirement is a rule of law to be obeyed. So if Missouri law and federal law have the same requirements, it's not in addition to or different from.
If they changed the label from what EPA had said, would they have been violating federal law?
So no, this goes more to impossibility. I agree with Justice Barrett. In this context, I don't see how impossibility and express preemption can come out differently. You have cases like Geyer where you say you can still go on to implied preemption, but here it requires parallelism.
But it's such a good
it can't be in
hypothetical
addition to or different
hash this
from,
stuff out.
so they have to be the same. Justice Thomas, you've talked about.
Just to go to my question, if you could.
Apologies.
Under federal law, if they do a different label than what EPA has approved, would they be violating federal law?
No. I think I win that 3 different ways. I don't think the statute prohibits a label change. Look at 136J. There's a long laundry list of prohibited acts. Changing the label unilaterally is not on that list. We've already talked about 136 AF1. I don't think that there's anything there that.
The Solicitor General's wrong about that?
Yeah, very respectfully, yes, he is. And you don't give deference to the Solicitor General in interpreting FIFRA. You look at the words for yourself. So yes, the United States is wrong about that. Then they go to the regulations. They quickly jump to the regulations. What's the source of authority for those regulations? If you ask the EPA, the source of authority for those regulations, I kid you not, it's 136 to 136Y. They cite the entire statute. That's their source of authority. If you cite the entire statute as your source of authority, that's a pretty good indication that you don't really have a good textual source of authority. Again, maybe in the Chevron regime, we might have looked past that. But we're in the Loper-Bright regime. I think you need affirmative text
Well,
before
Mr.
they can
Keller, did
regulate.
Loper-Bright say one word about preemption?
No, it doesn't. But
Loper Bright is about the relationship between two branches of the federal government, right?
Yours
Well,
and the
I
executive.
agree with that. I think it is always a separation of powers issue if you're going to ask whether the executive branch gets to pronounce what the law is instead of the judiciary. And
Which
then,
is what this
of course,
question is
that's
about,
relevant
right?
in the preemption context.
That's like,
Why is it relevant? Preemption involves the relationship between the federal government and the states.
It does, and under the Supremacy Clause, federal law is the supreme law of the land. So what counts as federal law is relevant to every preemption inquiry. I would be surprised if Loper Bright were somehow cabined and not applied in preemption cases where a regulation is doing the work to create preemption. You have the separation of powers problem plus a federalism problem because you're letting the executive, not Congress, preempt valid state law. That should only be done pursuant to a valid
Your
delegation.
prescience about where the law might go is interesting, but it's not there now, is it?
Well, I think that that's what you meant in Loper Bright. You all know better than I do what you really meant in Loper Bright. But I think a rule that says the Loper Bright regime is cabined to separation of powers cases and doesn't apply in preemption cases, I don't think makes analytical sense. You could draw that line. You've drawn lines before that maybe previously didn't occur to me that subsequently emerged. So I'm not going to tell you couldn't do it.
You think that would be an irrational line to draw?
I do, yes, because Loper Bright is asking the same sort of question. Who decides what the law is? Is it the judiciary or is it the executive branch? That is obviously relevant to preemption questions when we're trying to figure out what the law of the United States says.
Well, Loper Bright didn't suggest that Congress couldn't delegate power to agencies.
I agree.
And it seems here as though there's a pretty big delegation of power to APA.
I agree.
To figure all these matters out.
I agree there is an important set of delegated powers to EPA. And there are many that we haven't discussed that I do think would create labeling requirements. But the registration provision of 136A, which is where he and the government hang their hats, I do not think is this broad delegation to ultimately decide whether a pesticide is misbranded or not. I agree with you, though. There are
non-delegation doctrine? Anybody?
Delegations of authority that I do think could create labeling requirements. I can give you 136WC2.
Well, I mean, if we just sort of think about this scheme, right, it says to EPA, you have to do this big study, you have to weigh costs and benefits, you have to figure out on the basis of that whether to register a pesticide. You have to do that again every 15 years. You have to keep track of things in the interim. You have to, take seriously further information that industry gives you after registration. It just seems like a lot of stuff that the EPA does and is told by Congress to do to ensure the appropriateness of a particular pesticide.
I completely agree with you. FIFRA is structured in a way to maximally protect the consumer. So selling an unregistered pesticide is the first offense in 136J, but you also can't sell a misbranded pesticide. And so regardless of what the EPA says, they are not a safe harbor. They don't get to announce for you by registration all of those other provisions to protect the consumer from these dangerous products, which by definition kill living organisms. They just don't have that blanket immunity. I agree that EPA has all of those obligations, and though I think there are a lot of conscientious people working at that agency, I think we should also all agree that things slipped through the cracks with that agency. They were a decade behind schedule in their re-registration of Roundup, only to have their findings regarding human health vacated by the Ninth Circuit in a decision they don't challenge. So the last re-registration that we have is 30 years old, 1993. It would also probably not surprise you if they're not constantly keeping abreast of all of the annual reports. You've said similar things in the Food, Drug, and Cosmetic Act context, where there's a lot more rigorous upfront data because human data, phase 3 clinical trial data is given to the FDA. And even there, the FDA agrees that post-NDA application, post-approval, you can still have a misbranded drug. It shouldn't be less protective of consumers under the context of FIFRA, where the EPA is operating with less information.
On those points, can you speak to the petition process that Ms. Harris was addressing, the petition to change the process where you go to EPA and say, there's new science, you're behind the times,
He's pushing
everything
into
you just said.
all the places that the federal government sort of
I want you to address what
dropping the ball.
I actually think Ms. Harris said it exactly right. There is a process by which citizens, and I'll confess, I don't know if states can as well, but I'll take her word for it that states can also go and say, you shouldn't have re-registered this pesticide, and there can be a formal process. The agency, of course, would get deference, but there is judicial review under, I believe, 136N.
Are there any labeling and packaging requirements under this subchapter in your view?
Bad to
Yes,
eat
many.
Roundup? Yeah, I wouldn't
So
recommend it.
136WC2 is a good example of an interaction between what the agency
Tastes
does
terrible.
and labeling requirements. I think you can find that at page 48 of the red brief appendix. So 136WC2 invites the EPA by notice and comment rulemaking to designate a pesticide highly toxic to man. That designation creates labeling requirements because a highly toxic pesticide is misbranded if it doesn't have the skull and crossbones on the label, or if it doesn't have poison in red letters. That's 136Q2D. So if Missouri law said put poison in purple letters, it would be preempted. If Missouri law said don't scare consumers with the skull and crossbones, it would be preempted, and it would be preempted under FIFRA because it's the operation of the misbranding prohibition in conjunction with a valid delegation of authority. Congress knew how to delegate authority. The danger caution example in Bates is another one. 136A subsection D is where there's an express delegation to regulate, to create signal words on restricted use pesticides. So even though Bates didn't go into a long discussion of where that source of authority was, again, we were in the Chevron era, so it didn't have to, there's an actual delegation. Congress knows how to delegate this authority. It didn't through the registration process.
Thank you.
I'm happy to cede back time.
Wow, it's real quiet. I think they just used up all their energy on that first case. I think they're like ready to.
Thank you, counsel.
All right. Okay. So yeah, they are all ready. So we are heading back to
Mr. Clement?
Thank you, Mr. Chief Justice. Just a few quick points in rebuttal. My friend started with Bates. Bates really is distinguishable because it was mostly talking about efficacy and went out of its way to say safety is different. You can sort of think that in some respects Bates is like Lohr to Regal. Lohr said 510Ks. We really don't do a lot, so we're not focused on that much. There's nothing there to essentially have preemptive effect, but pre-market approval in Regal was different. I think it's the same with respect to efficacy and safety. On Regal itself, my friend offers two distinctions. I don't think either of them works. First, he says there's no equivalent to F2, but even without the equivalent of F2, nobody in Regal thought that just because you got pre-market approval, that didn't mean you couldn't possibly mislabel your device if you used labeling that was different from what was approved in the pre-market approval process. So F2 really doesn't do anything that wasn't already implicit. And then he also pointed to, he said, well, there's a statutory provision there that said that you can't change the labeling. If you look at the provision Justice Scalia cited there, you'll see that it's very analogous to the F1 provision that basically says you can't change the label, and you have to read the whole sentence because at the end it says without the approval of the agency. So Regal really is parallel here. The possible difference is there's still more open in this regime because you can have design defect claims. You can have states, if they really want to say you can't use it, states have options that they didn't have under the medical device amendments. So let me just finish with uniformity and practicality. On uniformity, it's worse than 50 states. It's every jury is a new day. And I checked, uniformity is a title, but it went through bicameralism and presentment just like the rest of the statute. So I think you have to take that seriously. Finally, just on the practicalities of this, if you tell any one of those juries that this fancy-sounding International Association on the Research of Cancer found a hazard warning for glyphosate, that sounds pretty bad. But every agency around the globe, New Zealand, Japan, Australia, the European Union, Canada, they've all looked at glyphosate. It's probably the most studied herbicide in the history of man. And they've all reached the conclusion based on more data and the kind of expert analysis they can do that there isn't a risk here. You shouldn't let a single Missouri jury second-guess that judgment. Thank you, Your Honors.
Thank you, counsel. The case is submitted.
All right. So to answer your question, CompuBear, so this suit, the way that they sued here was under a law that about mislabeling. My guess is that they used that because it's the most viable option. Otherwise, they would have done something different. So I'm just going to toss in there that it's probably the most viable option because, and it doesn't seem that viable, right? It's kind of a weird one. So it might be that there's not a great other way to sue. That said, currently Monsanto is considering, I believe, a $7 billion settlement over this. So they are at least considering the possibility of ending it that way. Yeah. So, and that's why I kind of wondered about that's why I was bringing up the tobacco thing, not because this is a tobacco case. You're part of the settlement. Okay. Not because this is the same thing as tobacco, because obviously this is under a whole different regime, but because the way that they settled tobacco and the way that the kind of timeline played out could be sort of similar, and at least would make an interesting legal hypothetical. And so that's why I really wanted to hear somebody say it. You know, how they went through all of the, you know, at what point did Big Tobacco know that it was dangerous? At what point did they release that it was dangerous? What were they doing to keep that information private? And then, you know, we move into the labeling regimes, all that stuff. I mean, there's a lot of enough similarities to at least make a really good hypothetical that I thought would have been an interesting way to hash it out. It sounded like by the time they got to that third lawyer, they had nothing to say. I was wondering, and somebody said this, and it's in my head, and I'm going to need to go look this up. One of the things that I consistently accuse myself of is not knowing, like at the end of an argument, you know, people are always like, oh, what, you know, how did it end up? I have no idea. I am not, there are lots of people who are great at this. I am not great at knowing. Like, I will often come out with the wrong impression, and the reason I think I do that is because I will listen to the arguments, and the people who are arguing are, particularly if there's like two people arguing the whole time, then, and the others are just quiet, it's usually because the others already know their answer and don't need to argue. And I am not great at hearing the silence. So one of the things that I'm wondering is if silence means that they'd already decided, sure, but that they'd already decided in favor or against, or if that means anything at all. And glyphosate hasn't been proven hazardous. It's just a good hypothetical. If it were, then you can look at because they're not just looking at glyphosate here, but how this law should be applied. And so kind of creating a hypothetical is a way to hash this out. And that's usually one of the ways we do it in law school. And so it's often one of the ways that they do it in court. I don't know if that's, probably chicken, egg. It's probably the court did it first. And so we do it in law school. But federal law does preempt state law here. And that's the whole thing, is that there's no deniability that the FIFRA labeling requirements do preempt state law. The question was, and the reason I drew that weird Venn diagram is that the argument of the guy from Missouri is that the two laws, the federal law and the state law, both say the exact same thing. And they both say, I mean, the wording is, and I was wondering if they were going to argue the wording. I'm glad they didn't, because I don't think it was worth arguing. But they say almost word for word the exact same thing. Where they deviate is what the EPA says in executing that federal law. And so that is what the guy from Missouri is arguing. We don't say, our law is absolutely 100% compliant with the federal law. The two are say exactly the same thing. The part where we don't agree is with what the EPA has said, and the EPA is not law, particularly post Loper-Bright. Loper-Bright is the case that overruled the Chevron doctrine and says that courts are allowed to interpret like what the EPA says now, instead of the EPA interpreting it for themselves. And that's why, the judge, I forget which judge it was, said, that seems, I think maybe Alito, of course it was Alito, said, I don't understand why you think that's a weird line to draw. And it was like, you don't? Because that seemed pretty, that was my reading of it. It seems like maybe he expected labor right to only work when he wanted it to, which sounds a little Alito. Skip for Brains brought up tobacco in the chambers, and I was thinking, so one of the things that I know happened, I don't know if this is still what's going on, but when DC banned indoor tobacco use, it was Congress exempted themselves because they wanted to keep doing what they were doing, particularly southern states, who it is bad politics to not have a cigar in your office. Oh wait, I want to skip over. Let's see here. So yeah, they were very quiet at the end. I don't know how that's going to play. But my initial thought was just that they're tired. But that said, it was, you know, like I said, I'm not great at guessing. Sometimes like a day or two later, after I've thought about it a little bit, I have a better answer. Okay. Yeah, I don't. My notes are a little bit less interesting there. So let me jump back to the first case, because that is, I think, that was a little bit more exciting. They ended up, well, the second one, the second one has huge implications, very, very important. It's just, I think it got a little quieter. All right. Make sure I'm not drawing on my head. So first case was about, oh yeah, thanks. Oh yeah, before I forget, because I got to keep saying it, I have 3 or 4 more days to hit before the end of the month. I don't have to do this as much next month. I have somebody who's going to stay with me and help a little bit, but I do need, before the end of this month, to hit a certain number, and I still got a ways to go. So if anybody can help, hit my Venmo. I would appreciate it, so that I can continue doing this for months longer, because I really do enjoy this. Okay. It's at BrynoDC. It's also my Cash App is $BrynoDC. Oh, thank you very much. 100 days. Cool. Awesome. Oh, and I hit my live goal too. Sweet. All right. All right, so let's talk Chatrie. So Chatrie was about cell phone data, and it was a lot. There was a lot that we went through. The big, huge deal, guys. I cannot tell you how big of a deal this was, because I was very, very concerned. There's this case from, if anybody watched my longer video, or any of the ones that I made yesterday about this, I think yesterday, maybe Saturday. Thanks, Jordan. About, what is it? Come on, brain. About Carpenter, which is the last time that the court really addressed this issue. And it was a slightly different case, but it was another one about location data. And, global site, yeah. It was another one about location data and when warrants were required and that sort of thing. And the court came up with 3 general factors to consider about location data and when it was going to be considered private and require Fourth Amendment protection. And the 3 requirements were how much information the data gives you about the person, how much data is actually being collected, and whether the data was given up voluntarily. Those are the 3 rules. But the thing that really grabbed my eye about that case were the dissents, because Gorsuch, Alito, and Thomas all dissented on a similar ground, which was to look back at the CAT standard, which is the reasonable expectation of privacy that we've been kind of relying on since the 60s, that says if you kind of reasonably believe that wherever you are is private, and in that case it was inside of a phone booth. He was on the phone inside of a phone booth, and the police knew he was going to be there, so they bugged it in advance. They knew this was his phone booth or whatever that he always used, so they bugged it in advance. If you reasonably, like not ridiculously, expect that it's going to be private in there, then the Fourth Amendment covers it, and it would be unreasonable to search or seize without a warrant. So that's CATS, and that's kind of been our rule ever since. And the Fourth Amendment doesn't say the words privacy anywhere. And so all three of those justices said some version of, we don't think privacy is protected by the, well, more broadly by the Constitution. They've been saying that for a while. But specifically, the Fourth Amendment does not protect privacy. It protects property, because what it says is persons, persons, papers, effects, and houses, I think is what it says. And they're like, that's property. So the government can't go into your property to get stuff. But privacy isn't in there. And I was very concerned that that's where we were going to go today, because I didn't know which way Barrett was going to go, and Kavanaugh's anybody's guess. Barrett was really the one that had me nervous, and one of the first things she said was, she kind of blew off the property thing and said, this seems like a question about reasonable expectation of privacy, which I was like, it was like, I can stop now, because this was such a big deal that that she had essentially staked her claim right there, that reasonable expectation of privacy was still where she believed we needed to put the line for protecting under the Fourth Amendment. And the fact that she said that means she's not rejecting. Gorsuch said he wouldn't even, in Carpenter, wouldn't even consider the privacy arguments, because he said the Fourth Amendment doesn't protect privacy. He's like, I wish that, they'd addressed property, because there's nothing I can do here. Fourth Amendment doesn't say anything about privacy. She went straight into it, and I was like, oh, because that's a big deal. If our government is not protecting privacy anymore, that's a big shift. And his argument was, well, your information is your property. Okay, cool. But it's still a different way of looking at it, and not a way that I necessarily love. So I was really, really concerned, and that made my day. Hearing her say that was just a huge deal for me. I was really concerned that they were going to go, that she in particular was going to go a different way, and we didn't really know how she was going to go. So now we know. Feeling better. The whole court has been moving away from this concept of protecting privacy in general. That is essentially how Roe was decided, or rather overturning Roe, because Roe was rooted in the penumbras of private, this idea that the Constitution generally protects privacy, and therefore there was this whole line of cases based on that concept. And the modern conservative court has been like, we don't think that's true. And so that's part of why Roe was overturned, is that it was rooted in that. So is our information our property? And that was the thing, is Gorsuch's argument, not Alito's or Thomas's, I don't think, definitely not Thomas's, was that it is, which is better than nothing. But it's still not, it was no longer protecting privacy at all. And that freaked me out a bit. So what Thomas said is that essentially your information, your location information, is the phone company's property. That's what he said in Carpenter, was that all of this information belonged to the phone company, so they could do whatever the heck they wanted with it. It was still the property argument, but in that case it's not even your property, so you don't get to say a thing about it. And that's part of the problem with using the property argument. As soon as you start talking about property, whose property is it? And that's when you have if we're talking about privacy, the privacy is attached to me. And that was one of the big things in Katz, is this discussion that kind of from that point forward, the Fourth Amendment, they said in Katz, protects people, not places. Before that time, it was only thought to protect places. And so if the government came into your house, there had to be some sort of an invasion before the Fourth Amendment would be implied. The Katz kind of changed the game and said, from now on, it's about the person, not where they are, not the place. So, and this was the thing, is my response, even if you wanted to go with, because Thomas has very extensive argument in Carpenter, if anybody wants to read it, where he goes through all this history of how property was looked at when they wrote the Fourth Amendment and whatever. what I think he just completely overlooks, intentionally or not, is that today, our information and the things that are used in court now aren't necessarily restricted to things that are written down on paper. Oh, thank you, Joe Mack. You had a lot of donuts. Thank you very much. They're not restricted to, back then, paper was so important because it was evidence in court. It was kind of the only thing that would freeze a moment in time was what was written on paper. Today, we have videos, we have your location data, we have all of this other stuff, which I think is the equivalent of 1790 paper. And I think the only way to categorize that today is with the word privacy. That is the only word that encompasses all of that stuff that I think was encompassed in the concept of paper in 1790, particularly if you're talking about the idea of what can be used against you in a crime, evidence of a crime. And the right to privacy under the umbrella of the 9th Amendment. Oh, I'm sorry, I thought that said 4th, sorry. And there's the 9th, I have big, strong things, but I try, particularly when I'm trying to rebut somebody's argument that's has a very specific angle, I try to rebut it in their own arena. I try to rebut it using their own the rules of their own game, and so I would probably not drag the 9th Amendment into an argument with Justice Thomas, because he's going to have this broad idea about the 9th Amendment and that it only proves that something's not there or whatever, or doesn't prove that anything is there. So that, anyway. Okay, sorry, off on a tangent. God, I know, me, right? So we talk, oh, there's Barrett, my big notes. Oh my gosh, reasonable expectation of privacy. Big note, Barrett just told us that she's not going to overturn cats. I was very excited. Not their own vernacular per se, so much as I try to restrict, I try to reframe my argument using their own, not just their terms, but the restrictions of their argument. And that's how you win. Because if there's part of the argument that they just blatantly don't believe is true, and you can waste a lot of energy fighting that one point, you might win, but you could get lost in the trees. So it's better if you can beat them on other points that they already agree with. It's just a more efficient way of winning an argument. It means often that I have to win an argument using much narrower things. And you'll hear in my videos a lot of times I won't talk about certain things and be like, why didn't you mention this? And it's because I am intentionally restricting this part of the argument to what the kind of the restrictions of the counter argument, which is something you learn to do as a lawyer if you want to win anyway. Does Thomas think the 9th Amendment is meaningless? Probably not, but my guess is, and he's not entirely wrong, the wording of the 9th says that just because something isn't listed doesn't mean it doesn't exist. But what it doesn't say is that anything in particular is there. It doesn't add anything. All it says is you can't remove anything. And so it's hard to use the 9th Amendment as a positive argument to say something is there. It doesn't say that anything is there. It just tells you that it's not there, if that makes sense. So it's particularly if you are somebody who only likes to see things that are in front of you, it's a tough argument to use, and it's a tough argument to use with somebody who only sees things in front of them. And so it's much better to beat them with things that are definitely there, words that are definitely there, use concepts that are in front of them, and that you don't have to fight for to begin with. Which, again, it's how you win. There's a strategy anyway. Vashon mentioned Commonwealth, we were talking about it, which I have a theory. Substantively, I don't think there is a difference between the word state and commonwealth, but I think the reason people used the word commonwealth, there was a philosopher, and I want to say it was Locke, I might be wrong, but it was one of those Enlightenment era philosophers that the people who, the Washington era people were really, really into, who wrote this whole super famous book using the word commonwealth a lot. And so I think people who were really into that dude really liked that word. It's similar to Plato's Republic in the idea that, people like using that word if they're really into like Plato or I think Cato, but people who are really into kind of classical philosophy really lean in sometimes to the word republic. And I think people who are really into Enlightenment philosophy leaned into the word commonwealth because of it was used by those philosophers. Was it Hobbes? It might have been Hobbes. It might be who I'm thinking of. But there's like in Plato's Republic, he like goes through and goes like, "This is the best republic." The book that I'm thinking of actually goes through and says essentially the same thing. This is the best commonwealth, and lays out like the difference between like a kingdom and a commonwealth. And so I think that word just became popular, even though it may not have a structural specific difference from some of the other words. So you end up with things like Virginia, those guys would have been super, super into those Enlightenment philosophers who named themselves a commonwealth. Only helps if someone is making the argument. Yeah, right. It's one of those things that helps when you need it. And particularity. I talked a bit about particularity. I thought they had some interesting things to talk about with particularity. There were some. This is part of the thing about that first case. There were some really interesting arguments on both sides. Just as far as structure and logic, some really interesting stuff got said. And I had some very point counterpoint moments like, oh, you got me. My notes are always unreadable. There was a lot of stuff. They went through that kind of a lot of hypotheticals. They used a lot of hypotheticals, and that's probably why I got into the mood of talking about hypotheticals. Hobbes' Leviathan, that might be it. I think it was. I think I'm specifically thinking of a Locke book, and I was looking over my shoulder to see if it was sitting right here somewhere, but it's not. I actually think it might be sitting over there. But I don't know. It could be. Leviathan is also sitting right there, so who knows? Oh, so many books. Somebody asked me the other day, I had one of my books upside down. They're like, "Is that there for a reason?" And I was like, "No, I don't remember. I was probably on my chair." I think especially since we moved away from the property privacy thing, I was way less concerned about that first case. I was really concerned about it if that was going to be the way we went. And so I became way less concerned about it once we kind of backed off a little bit, and I think it's going to be a lot narrower, and particularly since Carpenter already exists. And it didn't sound like they're going to overrule Carpenter, which was a 5-4 decision, and a lot of those people are gone now. So that was a possibility. Carpenter was about location data. And so that had me worried. But with Carpenter already in place, which already narrows and already says you have to have a warrant for collecting location information. And the government lawyer kept saying, if you are out in public, that is essentially the plain view doctrine. Like if you're standing on the street, then no matter how they get that information, they don't need a warrant to get it because you were standing on the street. The fact that you were standing on the street, anybody could see you. If they get it from your phone, if they get it from anything, they don't need a warrant to get it because you were standing on the street. I don't agree with that. You know, I can see that if, you know, and I understand these kind of plain view doctrine things and these things about, you know, if you're in a public place and surrounded by people, it's a little bit hard to argue that, but you don't need to get it through that. If you don't need to get it through that manner, if there are 500 people around who can say, yeah, I saw that guy there, okay, then you don't need a warrant. If you do need a warrant because there was nobody who saw them, then no, they weren't in a public place. People didn't see them. If they did see them, you'd know who they were. So I just, there's something in there. I don't know where the line is, but I feel like there's a line in there somewhere and it gets a little fuzzy in the middle. And particularly I'm thinking about situations where, you know, if you're walking in the woods alone and there's nobody for miles, then knowing exactly where you are doesn't necessarily seem like a piece of information that should be gatherable from your electronic equipment without at least asking a judge first. I think it is reasonable to assume that you can be somewhere in the world without people being able to find that out. I just feel like that should be something you can do if you really, really want to. And the fact that the government lawyer suggested that no, that is not something you can essentially ever do, just didn't sit right with me. But it also didn't sound like it sat right with any of the justices. So I don't think that's where we're going to go. So I don't think it's going to matter. I think they're going to end up, you know, maybe coming up with some sort of a rule, whether it goes one way or the other. It also doesn't sound like they're going to overturn this lower court ruling. I think one way or another, they're letting this stand because the exclusionary rule under the good faith exception, it just doesn't sound like any of them were interested in overturning this ruling. But I think even if they do, they're going to do it with some sort of, it might be dicta, but they'll have some sort of restriction on what we can do. And even if they don't, we still have Carpenter, which already said that. So even if they just say Carpenter still exists, that should be fine. As for the second case, you know, it's really just a question about preemption of, that's really what it's going to come down to, is whether or not the EPA gets to set these rules. And yeah, I don't know. I don't know. That's why I really do kind of wish they'd hashed out some hypos, because that would have helped me that would help me think it through a little bit more as far as whether, you know, if this is the only way, when it takes the government a while to figure out whether something is safe or not, if this is the only way to respond to it, which it sounds like it might be, then not allowing any means for it to go forward does seem problematic. On the other hand, they said that, you know, I did not realize that states can just absolutely ban this, which on the one hand means that there is another way. Missouri could just say, you can't use this here. Problem solved. But it does seem weird that they can say you can't use this here at all, but they can't add an extra label to it. I wondered if they could, like, wrap it in an extra label. Like, take the spray bottle and wrap it in cellophane and put a label on that. I don't know. The thing I did want to throw in there, though, because somebody did ask, is what the downside is. And, you know, one of the big complaints about Prop 65, is that what it is in California? Is that it had an idea behind it, had a reasonable theory behind it, which was that the state of California wanted to force everybody selling anything that might be cancerous in the state to label it as such, which isn't necessarily a problem, except that in order to kind of dilute it, companies started putting that label on everything they sold so that the label became meaningless. And so that's the problem, is if every state gets to put their own labels on something, then people don't know what labels mean. And that's part of the problem, is that you can dilute the meaning of something if there's no, you know, if you had a sticker, if you had a label on something that had 50 labels on, or 50 warnings on it, it's going to be, it's not going to have any meaning. And so that's, I think, part of the concern. So anyway, all right. I cannot remember what the case is about tomorrow. If anybody, again, wants to help and hit my Venmo, I would really appreciate it. I'm going to have to hit this week. I'm sorry. I have to keep asking. I don't love it. But I got to do something to hit my numbers before the end of the month. But I really, really appreciate everybody being here. And yeah, they have a cancer sticker on literally everything. And because if somebody eventually gets it, you anyway, whatever. Okay, sorry, oh, you're not talking to me. Okay. Yeah. Oh no, that's fine. You know, I gotta ask, but that was a lot, right? That was a lot. Tomorrow will be, yeah, I'll have, I'm going to take a little short break, and then I will get video ready for tomorrow. I did have, by the way, I have that, like I said, that 20-minute version of this morning's morning report that's just on Chatrie, which ended up being a little bit less relevant because it didn't come up. But there is still a lot of cool stuff in there about how the Fourth Amendment works, which may be worth watching. I decided, screw it, I wrote this 20-minute video, I'm going to record it anyway. So I just recorded both of them, and that's why I didn't get done until about 1 a.m. or 12:30 last night. And I'm like, so yeah, I'm going to take a break, and then I will get back on getting ready for tomorrow. Not sure, it's my fault, Jordan. I know what's going on. I'll fix it. I accidentally I logged the chat thing. It's really easy to do, and some days I screw it up. I logged the chat thing in twice. So it's my fault. Yep. It's the stack. Yeah, it's just I accidentally hit the login for Substack twice, and I just now noticed it. So, all right, everybody, I will see you guys all tomorrow, and thank you all for being here. Bye, everybody.